Lord, sir, lots of pleasure. Item 23, Lord, under the heading of it is required to be, Lord, should come under the heading of final dispute because the pleadings are complete now. Short synopsis has also been filed and further.
Don't mention cases for anything. You wait. If the case is not taken up, you come at around 4:30. We'll see what is to be done.
My last occasion also had mentioned, Lord, but it was not considered.
It was. You should come when I am rising. Then we will see what is to be done.
For final disposal, item 1, CRMP 694 of 2011, along with item 2 to 4.
Yes, in one case we could not finally because of some marriage is going to happen in the family of the
We will decide the case and reject all your interlocutory applications.
Not even Mr. Sharma,
We are not bothered about it. He's online.
Because of blogging, because of agitation in Delhi road, he's asking me to at least 2 and 3 minutes it will take to reach in my chamber. That is the reason he could not join.
We'll pass, but we will decide the case today. We will decide. We will take up the case on merits.
Yes,
we cannot postpone it for indefinite period of time.
Yes.
It is absolutely against the justice that investigation, etc. in FIR is pending because of your conduct. We will not adjourn it. Today I will not adjourn it. You just argue your case. If the opposite party is there, it's okay. If they are not there, we will decide the case in their absence also.
But seeking nearly 2 weeks of time.
1 minute time will not be granted. What do you mean 2? How many times have you taken adjournment?
2 and 3 times.
That is
yes,
all.
Of course taken, but we had bona fide filed in 3 matters.
Very good.
Only
Very
one.
good.
Only for one.
No.
One matter.
No. The matter cannot be partly compromised because the compromise was a composite compromise with regard to all the cases.
Yes.
Right? You have taken the court for a ride and you are unnecessarily keeping the matter pending. So today we are not going to adjourn.
Yes, of course, this is fault on our part.
Very good.
Still could
So
not find.
if it is fault on your part, then today
not on my part but our part.
All the pending interlocutory applications will be rejected, and then I'll place the matter for you start your arguments. You're laughing.
No.
When your client will go to jail, no, then you will appreciate better.
I am not laughing. Only because of some urgency that according to him.
There is no urgency. How many dates you have taken?
Yes.
The opposite party is also not there. They are not interested.
Even at the in terms of compromise that it is required to cooperate to both parties to settle the matter. Even we have cooperated.
So therefore, the parties are not cooperating for settlement of matter.
I am cooperating that one matter has been disposed of only on the basis of the compromise.
Maybe we are not concerned.
I am cooperating.
We are not concerned.
So
we are not concerned.
This is also that of course lawyer is not attending from Delhi, but he should the conducting lawyer.
Even they are not there. They are not. The private parties are not there to press the joint compromise petition. We can't do anything about it. We cannot pass the orders in the absence of the council. No, they are not attending.
Yes.
They are not attending.
Though I have also
okay, which one is their case? I will dismiss their case right now on account of non-appearance.
No, their case is not only my case.
In one case they are the petitioner.
No, they are not the petitioner. It has already been disposed of.
In all the petitions,
we are the petitioner.
We are
the petitioner. Their matter have been disposed of. All matters have been disposed of on the terms of compromise.
So you ask for recall of that order.
We
do not. We can't do it.
And I have been kept in abeyance only because at least in courtesy, even they are not appearing. So this is their.
So therefore, if they are not appearing, we can't force them, no?
Yes.
We can't force them to appear. They are not appearing. So therefore, now the matter has to be taken up on merits. IA is to be treated as not pressed, isn't it?
In theory, it has been filed.
It has been filed, but council is not there to press the IA application. Joint compromise petition, council is not there to press the interlocutory application. Then how can that be disposed of?
Yes, tell me.
So therefore, सब में आइए dismiss कर दीजिए, लाइए.
Your Lordship, at least pass over this matter so that I could ask them to come. At least pass over this matter.
Yes.
Pass over this matter.
And if you jointly pray for time, minimum 25,000 cost in each case will be imposed. These matters are not going to be adjourned without, if you jointly pray for time. And if you do not, they do not come, then the implicity applications will be dismissed.
Item 5, WPC 7479 of 2013.
Who is there for the petitioner? Who is there for the petitioner in this case? That's over. Next.
Item 6, WPS 5671 of 2014.
Yes, petitioner. Where is the petitioner? That's over.
Item 7, WPC 1450 of 2016.
Who is for the petitioner? That's over.
Item 8, WPS 6497 of 2016.
Thank for 2 weeks time, madam.
For what?
My PA is not arguing counsel is not.
Who is the arguing counsel?
Mr. Abhinay Kumar JC 28.
What has happened to him? Where is the charge memo? You have filed it on record? Where is it? Where is the charge memo? Petitioner, you have filed affidavit?
Yes, my lord. Actually, charge memo I have filed by severability.
Yes, you are.
Exact charge memo was not available, but I have filed it from the record.
Exact charge memo is not available. It means what?
But it is come in the input order, both by inquiry officer. Facts of the case. Little list of it. Ask them.
Yes, you argue. You argue your case.
Yes.
What is your petition and what is the point involved?
My lord, petitioner was dismissed twice for the same cause of action.
This is the main point.
Main point. First,
Just a moment. For the same charges?
for the same charge,
Okay. Let us see the charge, first charge and the second charge.
I filed some volunteer
No,
affidavit.
where is the first charge?
First charge was alleged against my
Where
petitioner.
is the charge memo? The charge?
So volunteer affidavit I have filed. my lord.
That is the only charge.
Only charge I am mentioning.
Yes. Read the charge.
In 30.
What is this? You are not even ready with the charge.
Hi, my lord.
What is the charge?
check here. Fine came, I know. Fine is 180.
Supplementary matter.
My lord, चार्ज है सॉलिडिटी में पुलिस 954 ओंकार कुमार ओम निवर्तन पुलिस अधीक्षक राजेंद्र प्रसाद सिंह के आदेश पाल के रूप में कार्यरत थे। श्री सिंह के आवास पर जलवाहक सुनील कुमार सिंह की उपस्थिति को भी प्रतिनिधि थी। श्री सिंह के आवास के सामने ओंकार कुमार ओम और जलवाहक सुनील कुमार सिंह अलग अलग कमरा में रहते थे। सुनील कुमार सिंह किचन नुमा कमरा में अपना 9,000 रुपये बैग में रखा था और 28/12 को वहाँ जलवाहक सुनील कुमार सिंह द्वारा अपना रुपया खोजा गया तो बैग में रुपया गायब था। आपको पूछने पर आपने उस जलवाहक को लिखित धमकी देते हुए चुप रहने की बात कही। आपके खिलाफ जलवाहक सुनील कुमार सिंह के द्वारा एक लिखित शिकायत पत्र समर्पित किया गया। इस घटना में पूरी छानबीन में पुलिस अधीक्षक बालेश्वर बैठा द्वारा कराई गई। छानबीन से पता चला कि 28/12/7 को आपके द्वारा 9,000 रुपया का बैंक ड्राफ्ट लेसीगंज बैंक में बनवाया था और अपने खाता में डालते हुए बैंक में जमा किया गया है, जिससे स्पष्ट होता है कि आप पर लगाया गया आरोप बिल्कुल सत्य है और मेरे द्वारा भी आपको पैसा वापस लौटाने की बात कही गई, परंतु आपने पैसा लौटाने से इनकार कर दिया। इस आरोप को में आपके बलादेश संख्या 780/2008 दिनांक 22/6/8 को द्वारा निलंबित किया गया। आपके द्वारा दिया गया स्पष्टीकरण संतोष पत्र नहीं पाने जाने के फलस्वरूप आपके विरुद्ध विभागीय कार्रवाई संख्या 15/2008 प्रारंभ की गई थी। आपके पूर्ण रूप में दोषी पाते हुए बलादेश संख्या
ये तो चार्ज मेमो नहीं।
चार्ज मेमो नहीं मैम, आई हैव नॉट, हम लिखे हैं चार्ज इज नॉट अवेलेबल बट दिस इज ए चार्ज अगेंस्ट मी। I have obtained from input order of inquiry report and also dismissal. I have obtained. यही है चार्ज। इवन इन रिवीजन सेकंड रिवीजन में डीजीपी ने कहा है कि दोनों का चार्ज में एक ही चीज आई।
Now let us see the facts.
Excellent. My lord, I want to draw your kind attention. Page number 2.
You just give me the sequence of event.
Sequence of event.
Yes.
My lord.
The alleged incident is of.
My lord.
What is the date of the alleged incident? Date of the alleged incident.
28/12/2000.
28/12/2007. Okay. Okay. Now give us the dates.
Then I was suspended. Then 28/12/2007 और शिकायत पत्र दिया लिखित 22/2/2008। उसी दिन मुझे सस्पेंड किया गया।
22/2/2008. Where is that? Where is it? This order of suspension? Where is this order of suspension?
Suspension given here, but I have been suspended.
Suspended for discharge. Then
they have started departmental proceeding against me. 15/2008 departmental proceeding number. 15/2008.
15/2008. What does that mean?
Departmental proceeding against me.
That's the number.
That's the number. 15/2008.
All right, that's right. DP.
Then
you participated.
Then departmental proceeding were conducted. Inquiry report DSP Baitha. They are preliminary examined, and he also become conducting officer of the inquiry.
Where is the inquiry report?
First of
Where is the inquiry report?
First one inquiry report I have. Second time when I have dismissed that inquiry report I have attached.
Where is the first time? You say that it is the same incident. You don't even have the charge memo. You don't even have
first inquiry report के बाद my dismissal was quashed by DGP by Annexure 2.
Let us see Annexure 2.
Annexure 2 पेज नंबर 27 देखा जाना है 25 Annexure 2
What is the date?
एक माइलर उनका आदेश है 1 मार्च 2011 को आदेश दिया डीजीपी ने जो कैश किया पहला ऑर्डर को स्पेशल पॉइंटिंग आउट की these are the different these are the shortcomings of the proceeding. So I am just reading that page number 27 last part my lord.
Yes.
संचालन पदाधिकारी ने जांच के क्रम में अपचारी को बैंक खाता की जांच किया तथा गवाहों का बयान लिया। जांचकर्ता के बैंक ड्राफ्ट और जमा रसीद की प्राप्ति रसीद अपना मंतव्य दिया। अपचारी द्वारा शिकायतकर्ता के रुपया चोरी किया गया है, जबकि मात्र एक गवाह झाड़ूकर संतोष कुमार राम ने अपने बयान में बताया कि सुनील कुमार सिंह ने कहा था कि उनका शक है कि उनका रुपया अपचारी ओंकार कुमार ओम नहीं चोरी किया है। विभागीय कार्रवाई के दौरान मात्र इस गवाह का रुपया अपचारी द्वारा चुराने की बात का शक की बात बताया। शेष अन्य गवाहों ने अपना रुपया अपचारी द्वारा चुरा लेने की बिंदु पर कुछ नहीं बताया। जांचकर्ता ने बैंक खाता की जांच नहीं की। जांचकर्ता ने शिकायतकर्ता के बैंक की खाता की जांच नहीं की है। उन्होंने कहा है कि बैंक से रुपया निकासी किया था। शिकायतकर्ता बैंक के रुपया निकालकर जांचकर्ता प्रकोष्ठ अनि रामानंद सिंह के पास रखने की बात कहा गया था, लेकिन जांचकर्ता द्वारा संचालक पदाधिकारी द्वारा अनि रामानंद सिंह का बयान नहीं लिया गया तथा विभागीय कार्रवाई के दौरान भी उनसे पूछताछ नहीं किया गया। सबसे बड़ी त्रुटि यह है कि शिकायतकर्ता जवाहर सुनील कुमार आवेदन की जांच पदाधिकारी परिसर बैठा पुलिस उपाधीक्षक थे और उन्हें ही इस विभागीय कार्रवाई का संचालन पदाधिकारी बनाया गया, जबकि उन्हें इस विभागीय कार्रवाई को साक्षी होना चाहिए था। उपयुक्त त्रुटियों की स्पष्ट है कि इस विभागीय कार्रवाई का संचालन विधिवत नहीं किया गया है, प्राकृतिक न्याय प्रिंसिपल ऑफ नेचुरल जस्टिस के अनुकूल नहीं है। अतः इस विभागीय कार्रवाई के संचालन में पाई गई लिखित त्रुटियों के मद्देनजर अपचारी पुलिस ओंकार कुमार के विरुद्ध इस विभागीय कार्रवाई में पारित आदेश को निरस्त करते हुए अपचारी को पुनः सेवा में लेने का आदेश दिया तथा पुलिस उप महानिरीक्षक झारखंड झारखंड सशस्त्र पुलिस 8 लेफ्टिनेंट पलामू को त्रुटियों के लिए इस विभागीय कार्रवाई को पुनः संचालन नए सिरे से नए संचालन पदाधिकारी नियुक्त करें।
Then what happened?
लेकिन then they have started another proceeding.
That's
Page number 36, Annexure 5. In that proceeding, I have been found no guilty, no charge. But page number
Annexure
Annexure
5.
5.
Okay. Then Annexure 5 was instituted.
Yes, my lord.
Then this is the inquiry report, perhaps. What happened thereafter? After this,
They have
after this
appointed me.
order,
They have
took
appointed
you
me.
back. That's right.
They have
And then,
appointed me.
and then,
Worship,
that's
thereafter,
right.
petitioner was reinstated.
Just a moment. Let him
Reinstated.
complete.
Yes.
I listened. Okay. Then what happened?
I was reinstated on 22/3/2011.
Okay. Then
Then another proceeding was started, proceeding number 711, in which inquiry officer DSP Divakar Shankar Prasad ji 19/10/2011 को नो गिल्टी किया। वो पेज नंबर उनका
did you participate in the inquiry?
yes, I participated और उनका इंक्वायरी रिपोर्ट का मंतव्य कॉलम हम पढ़ लेते हैं जी।
Okay.
39
प्रमाणित नहीं होते हैं.
हाँ,
Right?
38 पेज में।
Okay.
If
I've seen it. Then what happened?
Then another fresh inquiry officer was appointed. ये कहते हुए कि I will let supplementary, they have submitted supplementary affidavit in which the disciplinary officer has changed the inquiry officer.
Fresh inquiry officer.
Fresh inquiry officer. They can ask my officer, you can do it.
What is Annexure 6?
He has found
What is
that
Annexure
he
6?
has supplementary.
What is Annexure 6?
Annexure 6 is a dismissal. Of
No.
second
You
dismissal.
say
Second
say
dismissal.
that just a moment. You say on 7/11, they had passed, the inquiry officer had exonerated you,
Yes.
right? Then when did they start the second inquiry?
They were started
19/10/2011 is the inquiry report exonerating you, right?
Yes, my lord, on 5, they have exonerated me 19/10/11.
That's right. The inquiry officer.
Inquiry officer.
Then what happened?
Then they have changed another inquiry. They have
Who was the inquiry officer earlier? What was the name of the inquiry officer
Divakar
earlier?
Shankar Prasad, first inquiry.
Divakar Shankar Prasad.
Diva Shankar Prasad.
Okay. Who is the subsequent inquiry officer?
Birsa Ram Khalko.
Sorry?
Birsa Ram Khalko.
Birsa Ram.
He submitted inquiry report on
Where is the inquiry report?
supplementary affidavit, my lord. He has
Supplementary affidavit. You will not disclose that there is a fresh
Lordship
inquiry.
have asked him. Lordship have asked, responded to some.
You see, the court might have asked, but
No,
is it not something which you should have disclosed?
That was not available to me.
You did not participate in the second inquiry.
I have participated.
Then why did you file the second inquiry report?
My lord, I have filed earlier in 2009 one WPS that was DFD, that might be in that. तो DFD हो गया था उसके बाद हम तब तक रजिस्ट्रेट हो गए थे. In the meantime,
You filed WPS number. What was the number?
6034 2000 annexure 11, my lord. Annexure
WPS
11.
number?
Page number, my lord.
WPS number.
WPS number 6434 6034 2009.
It was dismissed for default.
Default.
You challenged which order in this?
I have challenged, my lord, in 6497. I am challenging this.
I want to know in this writ petition which order did you challenge?
Annexure 11, my lord, page number 61. The input order there, पहले वाला discuss हुआ. अभी तो इसके साथ वो वाला तो discuss हो गया.
Which order did you challenge in the year 2009?
अभी outer challenge किए, my lord, 6 annexure 6.
I just want to know, if you will not answer this question.
No, listen to me, my lord. I have a next
I am
one.
listening to you. I just want to know which order did you challenge in WPS number 6034 of 2009?
Previously, that was exonerated by DGP. और उसके बाद हम लोग.
Why did you, when you were exonerated by DGP, why did you file a writ petition?
Before
that
that.
order was in your favor.
That was my favor, but before dismissal they have filed. Before question of the judgment of the order of the by DGP, they have filed. He might have filed. I was not his counsel.
Very good.
On that day,
You see,
I was not counsel.
then what happened? Where is the second inquiry?
Order of DGP on 2011 was.
That's it.
Then, my lord, another dismissal was passed by respondent member.
No, where is the second inquiry? Further inquiry?
For second
You
inquiry.
said somebody called Mr. Mehto was the second inquiry officer.
Yes,
Where
ma'am.
is that?
Supplementary
Inquiry
affidavit.
report.
By supplementary affidavit by respondent they have submitted.
Where is that? Where is the inquiry report?
Annexure D of the supplementary counter.
Supplementary.
Page number 14. The new inquiry officer was appointed.
All right. And he participated also?
Yes, Lordship.
But he did not disclose it in the
He didn't say anything. It just came on record, Lordship.
The glaring defect in that inquiry report, my lord, the Khalko inquiry officer Khalko did not examine the complainant.
So?
So no cross. I have participated, but he has not examined. पेज उनका जो पेज में लिखा है कि हमने उनका मतलब कॉलम को केवल देखा.
Then what happened after this second inquiry report?
They found me guilty. दोषी करा दिया और thereafter commanded dismiss me on 28 March 2012.
Second show cause must have been issued to you.
हाँ.
Where is the second show cause?
Second
The
show cause.
complainant was not examined.
Second so called they have issued by now.
So second show cause is on page number
There is number by law.
28 of supplementary.
Yes. I have prayed for time. He has given me only
On both the time, even on the first show cause and even on the second show cause, petitioner was praying for time only.
what with time. He has given me notice on 21 दिन और 28 को डिसमिस किया उन्होंने. 21 दिन को नोटिस दिया कि आप जवाब दीजिए. और नहीं है डिसमिस में ना 28
21/3/2013 को नोटिस दिया.
हाँ.
Second
And he
show cause.
dismissed me on 28/3.
You did not appear. You were not cooperating with the inquiry officer himself.
Well,
You did not respond.
I have responded. I have participated.
Is it wrongly mentioned? Page number
But
16.
he told me कि अंतिम बचाव पत्र दो. For that I have demanded time from the inquiry officer.
देखिए अगर आपकी बात और रिकॉर्ड में मिसमैच
हम
होगा ना,
वो जो इन्होंने सबमिट
अगर
किया
आपकी बात और रिकॉर्ड में मिसमैच होगा
No,
ना,
no, never.
तो 226 हम ऐसे ही डिसमिस कर सकते
No, ठीक है कर सकते
हैं, है ना? पेज नंबर 16 में आइए ऑफ सप्लीमेंट्री एफिडेविट.
पेज नंबर 60.
बचाव पक्ष द्वारा सफाई.
हाँ.
पढ़िए. पढ़िए.
मांगी गई थी, विस्तार के लिए मांगी गई थी.
आगे.
परंतु समादेष्टा द्वारा 3 दिनों का विस्तार किया गया. इसके बावजूद आरोपी द्वारा बचाव स्पष्टीकरण समर्पित नहीं किया गया.
आगे पढ़िए.
पूर्व संचालन दिवाकर प्रसाद पुलिस उपाधीक्षक.
So you did not cooperate with the inquiry officer at all.
I have cooperated, my lord.
You just told me. You just said
They
that
have-
you were fully cooperating. You have
They
not
have
even
dis-
given
they
your.
have dismissed me without giving me proper time. Educate opportunity नहीं मिला और हमने हमारा.
Did you file your second show cause? Reply to the second show cause?
No, हमने नहीं दिया. हमने एक सप्ताह 10 दिन का टाइम मांगा था, नहीं दिया गया. 28 को 31 को रिटायर कर रहे थे, 28 को डिसमिस कर दिया. He was on the verge of retirement, and that commandant was also dismissed in the first time. He is a authority who dismissed me in the 2009, and again he has dismissed in 2012.
I've heard you enough. Yes, बताइए.
Lordship, at first, Lordship, that order of DGP in the year 2011, Lordship, there was some irregularity. That's why that order was quashed. With the disciplinary authorities order was quashed, and thereafter a fresh inquiry was made. The findings of the inquiry officer, Lordship, that was not right, as the documents has been not been perused by the inquiry officer. Then a new inquiry officer was appointed, Lordship, that is Annexure 8.
Then you will go for further inquiry or you will go for fresh inquiry?
Lordship, it is upon the disciplinary authority.
Where is that order by which he asks for fresh inquiry or further inquiry?
Lordship, that is
And can he change the inquiry officer in the manner he has done? Can the disciplinary authority go on changing the inquiry officer till he gets a favorable report?
No, Lordship, even if the new inquiry was conducted, he was not cooperating. The petition.
That is a separate thing.
Yes, Lordship.
Can you straight away go and appoint a fresh inquiry officer merely because the inquiry officer has not given you a favorable report? Where is the order by which fresh inquiry officer was appointed? Where is that?
It is written on Annexure A, Lordship.
Annexure A to the.
A of the supplementary counter affidavit.
Okay.
Page 11.
आप बैठ जाइए please. This is supplementary counter affidavit is dated page 11.
Dated
Okay, yes,
7/12 of 2020.
Yes, page 11. Kindly
Page
tell
11.
us what is
It is
it?
written on the bottom side, Lordship. मैंने पुलिस उपाधीक्षक सह संचालन पदाधिकारी के मंतव्य का अवलोकन किया। संचालन पदाधिकारी द्वारा संचालन के दौरान केवल मौखिक बयान को सही मानकर और उसी को आधार मानकर आरोपित को आरोप से बरी कर दिया गया। कहीं भी अभिलेख साक्ष्यों का उल्लेख नहीं किया गया है। मैं इस मंतव्य से सहमत नहीं हूं, अतः पुनः संचालन के लिए पुलिस उपाधीक्षक श्री बिरसा राम खलखो को प्राधिकृत किया जाता है।
And then you issued him the second show cause.
Yes, no, first show cause.
Okay, then you issued him the first show cause. That is annexure B.
Yes, Lordship.
All right.
First
Then
show.
annexure C.
Annexure C, Lordship.
Where is the second show cause?
That is annexure E.
Annexure E.
First show cause was issued. Petitioner was seeking time instead of giving reply to the show cause, Lordship. That is annexure C. Petitioner was seeking time. Thereafter, the inquiry report, Lordship, where can we see the witness, Lordship? Witness number 5 on page number 15, Lordship.
Yes.
May I read it, Lordship? साक्षी श्री शैलेंद्र राम, लेस्ली मोची, झारखंड पुलिस सेवा लेस्लीगंज पलामू ने अपना बयान में बताया कि घटना के बाद वर्ष 2007 में बैरक नंबर 2 रूम नंबर 15 में ये साथ में पेंटर पुलिस संख्या सचन सच मोहम्मद बशीर अली दर्जी, पुलिस मोइन अंसारी, विकास तिवारी, झाड़ूकस, जूनस भेंगरा, सभी झारखंड पुलिस सेवा लेस्लीगंज पलामू बैठे थे। सुनील कुमार सिंह जलवाहक वहां पर पहुंचे। आपस में हम लोग बातचीत कर रहे थे कि सुनील कुमार सिंह का रुपया भुलाया है या नहीं, हम लोग नहीं देखे हैं, किंतु सुनील कुमार सिंह कह रहा था कि ओमकार रुपया लिया है। तब हम लोग समझौता किए कि रुपया भुलाया है या नहीं हम लोग को नहीं जानते, लेकिन रिपोर्ट करने से एक आदमी का नौकरी चला जाएगा। आप दोनों आपस में समझौता कर लीजिए। हम लोग दोनों से सुनील कुमार सिंह एवं ओमकार बोले कि आधा आधा दोनों सह लीजिए। हम लोग बोले कि सुनील कुमार सिंह 5,000 रुपये लेकर मामला खत्म कर दीजिए तो ठीक है। तब सुनील कुमार सिंह मेस चला गया। ओमकार इस बात पे राजी हो गया। इफ द पिटिशनर हैज नॉट टेकन द मनी, by the petitioner.
Let us see the inquiry report which you have annexed,
Yes, sir.
along with which you were not agreeable. What was the so blatant error in this inquiry report?
That inquiry report is on annexure.
Where is that inquiry report?
Annexure 6, Lordship.
Annexure 6 of the writ petition?
Writ petition.
You say that the material witnesses were not examined.
Yes, Lordship. The documents, how much money has been taken, where it has been deposited or not, these
These aspects were not considered.
Yes, Lordship. And the same thing has been come that आधा आधा पैसा सह लीजिए वाला बात, Lordship. It has not been considered by the then inquiry officer, Lordship. If he was not guilty, why he was paying rupees 5,000 to that Sunil Kumar, Lordship?
That's all. You have, this is your document. This is what you have submitted. Who has filed it?
My Lordship,
Aapne filed it? No, there are two things. One is brief facts of the case with list of dates on behalf of the respondent, and this is on your behalf. You don't recognize your document.
Synopsis fact.
This is your document.
Yes.
Okay.
Synopsis fact.
That's all. ये आपका है, right?
My lord, in the input order, in the dismissal input order, commandant himself admitted कि आरोपी पर लगाए गए आरोप की पुष्टि नहीं हुई है, परंतु रुपया चोरी होने की बात को उन्होंने स्वीकारा है। स्वीकारा किसके सामने, कहीं कोई बात कोई है नहीं, संदेह पर सब बात
We'll see that. We'll see that. We'll go through the records.
ये इन्होंने बता रहा है कि कोई पुष्टि नहीं हुई है इंक्वायरी गवाहों के बयान से पुष्टि नहीं हुई है चोरी की। दूसरी बात ये है माय लॉर्ड कि सेकंड इंक्वायरी ऑफिसर वाज हैव नॉट एग्जामिन द कंप्लेनेंट, दे सिंपली परदस को परदस मान लिया, उसका लिखित प्रतिवेदन को परदस मान लिया, दे हैव नॉट एग्जामिन द सेकंड, सो आई हैव गॉट नो अपॉर्चुनिटी। उस पर जजमेंट हमने दिया है कि अगर सेकंड अगर उस कंप्लेनेंट का हम एग्जामिन का मौका नहीं
Why
मिला,
didn't you examine the complainant? Any explanation? कौन सा judgment है आपका? Which judgment?
जजमेंट भी आई हैव गिवन जजमेंट
Which, where is that judgment?
लगाए जजमेंट सिमिलरिटी एफिडेविट लगाए हैं। आई हैव annexed the two order and on this court and the order of appeals court of my court, page number 11 of my supplementary affidavit.
Page number 11 is this one.
Yes,
And
ma'am.
where is the other one?
Other one, my lord, coordinate bench of this court, my lord, page number 70. Non-examination of complaint.
That's right. Okay. Learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner was subjected to disciplinary proceedings which was initiated by disciplinary proceeding number 15 of 2008, and ultimately when the matter was placed before the respondent number 3, the punishment imposed against the petitioner was set aside on ground of violation of principles of natural justice and other considerations, and liberty was given to the respondent number 3 to initiate fresh proceedings. The petitioner was directed to be reinstated in service. Consequently, the petitioner was reinstated on 22/3/2011. The learned counsel submits that thereafter another departmental proceeding was initiated, which was numbered as departmental proceeding number 7 of 2011, wherein one Divakar Sharma, Divashankar Prasad was made the inquiry officer, and who submitted an inquiry report exonerating the petitioner from the by giving a report in favor of the petitioner and stating that the charges against the petitioner was not proved in the inquiry. The learned counsel submits that thereafter the disciplinary authority appointed another inquiry officer, namely Birsa Ram Khalko, and he submitted another inquiry report finding the petitioner guilty. The learned counsel submits that that so far as the third inquiry report is concerned, so far as the second inquiry report in the disciplinary proceeding number 7 of 2011 is concerned, the complainant was not examined, and therefore the charge cannot be said to have been proved. He has also submitted that there is no reason for not examining the complainant. The learned counsel has submitted that since the charge was regarding stealing of money of the complainant, it was incumbent upon the respondents to examine the complainant. The complainant having not been examined, the entire proceeding is vitiated. The Learned Counsel has also submitted that a second show cause notice was issued to the complainant, but very short time was granted and he could not file a response to the second show cause notice, and ultimately the petitioner has been dismissed. Did you avail any of the remedies? Appeal? No. Did you avail appeal?
No. Yeah, I have gone to dismissal against to DIG and DGP also. They have also.
Okay. The
they have
Learned
also
Counsel has
affirmed the
submitted
order.
that the appellate authority and the revisional authority have also not considered this aspect of the matter, and therefore the present petition is fit to be allowed. The Learned Counsel has relied upon the judgments passed by Honorable Supreme Court reported in bracket 2011 bracket 6 SCC 376 within bracket Commissioner of Police Delhi and others versus Jai Bhagwan, and also a judgment passed by a coordinate bench of this court in WPS number 3971 of 2012 decided on 3/9/2012.
You also brought another judgment.
On the same point, no?
On the same point.
So you want, what is the big idea? On the same point, one judgment is sufficient. Like the Learned Counsel has also
Second.
relied upon a judgment passed by a coordinate bench of this court in WPS number 1248 of 2013 dated 29/11/2013 to submit that once an inquiry report has been submitted, there was no justification for the disciplinary authority to appoint another inquiry officer. यही है, इसीलिए जजमेंट दिए. Right. इसमें स्वामी विभुदेव वर्सेस स्टेट ऑफ झारखंड decided on 29/11/2013. That is all. The Learned Counsel appearing on behalf of the respondents, on the other hand, has opposed the prayer and has submitted that so far as the initial inquiry is concerned, the matter was remanded for initiation of fresh inquiry, and thereafter the fresh inquiry was initiated by Departmental Inquiry number 7 of 2011. The Learned Counsel has referred to the inquiry report, submitted pursuant thereto, and has submitted that the inquiry was not properly conducted, and
without perusing the documents.
And even the documents were not perused. The manner in which the inquiry was conducted was totally unsatisfactory, and consequently the disciplinary authority appointed another inquiry report. The Learned Counsel submits that the order by which the disciplinary authority appointed another inquiry report has been filed along with the supplementary counter affidavit
Yes, Lordship.
dated
The third inquiry report.
dated
Dated, Lordship,
as 7/12/2023. He refers to annexure A thereto, and he has submitted that the disciplinary authority has asked for fresh inquiry by endorsement dated 22/11/2011, clearly citing the reasons for the requirement of second inquiry. The Learned Counsel has submitted that though the complainant was not examined subsequently.
no, Lordship. From perusal of this inquiry report.
Sorry.
From perusal of this inquiry
From
report.
perusal of the subsequent inquiry report, the Learned Counsel submits that though the complainant was not examined, but there were other evidences produced on record, and the petitioner was totally non-cooperative in as much as he did not even furnish his defense statement before the inquiry officer. The Learned Counsel submits that that in such circumstances, the inquiry officer rightly held the petitioner
From
guilty.
From perusal of the witnesses, it has also come that petitioner was willing to pay half of the amount. Which
The
had been
learned
estimated.
counsel has also submitted that the witnesses had also deposed that the petitioner was willing to pay half of the amount
Which have been
which was taken away by the petitioner, which itself indicated that the petitioner was guilty of the charges which was leveled against him. The learned counsel has submitted that the petitioner did not even respond to the second show cause reply, and therefore the impugned orders do not call for any interference. That's it?
Yes.
Order reserved. And order reserve मत करिए, एक date दीजिए. We'll put a date for judgment, right?
Okay.
Pose this case for judgment on 12th of April. Next call.
Item 9, WPS 5107 of 2017.
Passover will be taken up at 4 o'clock.
Item 9,
4 बजे. Who is for the petition?
Yes, sir.
Your Lordship. Yes.
Pursuant to the last order, the petitioner has filed a supplementary affidavit.
You have filed the affidavit.
Your
What about
Lordship.
you?
Your Lordship, I seek apology, Your Lordship, I had to file a reply to the supplementaries. Lordship, I was not able to file a reply.
Why were you not able to file?
It was to be filed within a specific time stipulated by this honorable court.
Why have you not filed it?
Your Lordship, it was a mistake on my part, Your Lordship.
On your part? You did not communicate.
Your Lordship, it was a mistake on my part, Your Lordship, it was missed, Your Lordship. I seek apology of the court, Your Lordship.
When did you communicate ultimately?
Your Lordship, last week.
Date. Date of the letter is required. When did you communicate?
Your Lordship, last week.
Don't be
when
so
the matter-
casual. We are not used to such casual submissions. When did you communicate?
Your Lordship, last week when the matter was listed.
Date. This is parted.
Yes, part
Yes, I
especially
know.
assigned matter, and it is parted also.
Yes. When did you communicate? Tell me the date of the letter. You must have communicated through email or maybe through letter. Give me the date.
Your Lordship, I'll have to check the date of the letter.
You go and bring the date. I will record it in the order. It has to come from the Honorable Chancellor.
Yes, it-
Yes. So that date has to be there.
Your Lordship, it was a
We will
mistake.
not. You have made a statement. You give me the date. Bring the date. Tell me, next. 4 o'clock. You come at 4 o'clock. Give me the date of the letter.
Item 10, WPC 3887 of 2020 along with item 11.
Lordship, with your due permission, Lordship, we are seeking for adjournment in this case. Lordship. Actually, Mr. Advocate General has to assist his court, Lordship, in this case. Lordship.
I'm hearing the petitioner. You note down,
As much.
right?
As much.
Let me hear the petitioner.
As much.
Because it will, as it is, this matter is not going to end in one day. So let me just understand the contours of their arguments, and then we can post it at your convenience, but on the next date, there will be no adjournment, right?
I will assure that.
Who is appearing? Are you appearing? इसको पूरा full screen करें. Yes, are you appearing? थोड़ा voice. Let me just increase the volume. I don't know, there is. Our volume is full. Anyways, you can continue. Yeah, but still the volume is not sufficient. some problem at your end. Please.
I'm
That's
able
right.
to hear your lordship.
Yeah, that's right.
quite well.
That's right. Yes.
Yeah. Okay. Now, over the time, the entire matter has actually come in a very short compass. Originally, we had challenged the two electricity bills.
I'll just come to that. We can hear the matter in two manners. You can initially formulate the question that you want to place before this court. Then give the list of dates, because list of dates would be important. And then we can proceed. And I want to know that whether the issues which are involved in this case, which you want to be adjudicated as of now, is it totally delinked with the other issue which is pending before the Supreme Court, or it has some link because the matter relates to KVA charges?
Lordship, I am grateful.
Right. So
there are three issues, my lords, here, because there are three amounts involved.
All right.
I must be fair in indicating that one of the amounts, as per the respondents, is connected to the Supreme Court matter. Though I may dispute, I would submit that that actually can be kept separately, because that is also part of the connected writ petition. So I would not be troubling your lordship on that amount.
It is a part of both the writ petitions, or it's a part of only one of the writ petitions?
So it is one of the writ petition, it is challenged, and it is indicated in the bill, which is now a part of this writ petition. So I would not be touching upon that, because that should then be kept pending in terms of what would happen in the Supreme Court.
Okay.
One of the amounts. Now the second amount,
is it possible to dispose of that matter by indicating that your right to file a fresh writ petition would revive once the matter is ultimately decided by the Honorable Supreme Court?
So, my lord, in that matter, that is filed by the respondents.
Okay, that is
Because
filed by the respondents.
Yes. I had succeeded if it is filed by the respondents. Now their claim is that it is dependent upon the Supreme Court judgment.
Okay. They had filed that case prior to Supreme Court matter was filed, or they have filed it subsequently?
I believe it was subsequent. But then they are saying that it is the issue about the HTSS and whether the Lakshmi business judgment of the Honorable Supreme Court would be applicable in that matter.
Okay.
And so that repetition can probably be taken up at a later stage subject to
That is the solitary issue involved in that repetition.
My lords.
Okay. Now let us see what is your case.
My lords, may I invite your lordship's kind attention to a short written submissions which I had filed yesterday.
Yes.
So I have attempted to place all the issues which I want to place on record.
That's
My lords, have it. This is submissions on behalf of the petitioner.
That's right.
So, my lords, originally the writ petition was filed challenging two electricity bills. One was 9/8/2008 and 9/11/2020. During the course of the pendency, the respondents issued a revised provisional final bill of 26th April 2023 and also a disconnection notice of 16/6/2021. We had moved amendment application and my lord was kind enough to allow, so we amended the prayer. In para 1, I have indicated what exactly I have challenged. So, my lords, on the last occasion on 30th October, when the matter had been taken up, the final, what I call all the bills kind of now merge into the revised provisional final bill dated 26th April 2023. So I had submitted for lordship's consideration 3 points over here. First, my lords, was that as regards the alleged arrears of 9 crores 36 lakhs 79,135, no details were provided by the respondents in the bill. It was just a mere saying arrears and this amount.
Okay.
Then, my lords,
So you are absolutely clueless as to what is this amount all about.
Lordship pieces. So my lords had directed them to file an affidavit, and I will show that affidavit equally is absolutely clueless.
Okay.
So this is the first point, my lords. The second, my lords, lordship may kindly see page number 2 on top, para B. In that very bill, they have indicated that 3 crore 21 lakhs 29,513. This has been kept in abeyance and it requires to be refunded to the petitioner. That is noted in the bill itself. I will show in the document. And in C, again there no explanation with respect to this third amount, 2 crore 58 lakhs 42,428, which again has been kept in abeyance in terms of that bill itself, and it's required to be refunded. So
There
this
is that
where
2 crore
these
figure.
points.
I have got the figure of 9 crore. I have got the figure of 3 crore. Where is the 2 crore figure? Next page.
See, my lords.
All right. All right.
2 crore 58 lakhs. So these were the three submissions
And
I made your lordship.
Which one is
on-
pending before the Supreme Court? That is
Uh,
3
so-
crore
so
21.
much-
Which one is
so
pending?
much concern, that is 3 crores.
Okay, so you are not concerned with this as of now.
So 3 crores, my lords, my submission is that can actually be kept as it is in terms of whatever the outcome of the Supreme Court would be. So, my lords, in view of this, my lords, your lordship had on 13th of October directed them to file a supplementary affidavit giving details with respect to all these three figures. Now, they had filed an affidavit, my lords, on 8th of November 2023,
Yes.
which I have noted in para 4. My lords, may kindly see this affidavit. 8th November 2023.
November 23. सेकेंड कॉपी को अलग कर देना चाहिए ना फर्स्ट कॉपी की जगह सेकेंड कॉपी दे देना ये फर्स्ट कॉपी ये क्या है WPC से फोटो कॉपी लगाओ ये क्या है इसको गड़बड़ हो जाएगा बताइए 1st November 23.
8th November 2023.
Yes. 18/1/24 I have.
Just before that, my lords.
2nd of January 23 I have. 22/11 I have. 8th November 23, yes.
This is titled Counter Affidavit on behalf of respondent.
Kindly place this.
My lords, may kindly see paragraph 5 at page 3. Paragraph 5.
Yes.
That the instant writ application has been filed for quashing the bill dated 9/11/2020 towards bill for the month of October 2020, wherein an amount of
You can come to the relevant portion. That is at page number 4.
May kindly see paragraph 7.
Para 7, yes. 4 crore 56 lakhs.
So this is the same 3 crore 21 lakhs with interest.
Okay.
So it comes to 4.56. So this was kept in abeyance as the case of actual KVA in the matter of HTSS consumer is at present under adjudication.
Very fine. There is no dispute on that. Next.
This is one.
All right.
Then my lords, may kindly see over the page the last 4 lines at page number 5. This is with respect to the second amount, my lords.
Yes.
An appeal was filed by the JBBNL before the Ombudsman, and Ombudsman upheld the decision of so and so. Due to no guidance provided from board, an amount of rupees so and so, being the difference of billed KVA and actual KVA from April 24 to March 2008, was kept in abeyance. Since the board has filed an appeal in High Court and the matter was under dispute, thus total rupees 3.22 crores is kept in abeyance. This is the second writ petition, my lords. So though again they have changed
No,
the figures,
just a moment. Let's be very clear on this. In para 7, they talk about 4.56 crores, and you say that this is the figure 3.2521 crores plus interest, right? And the entire paragraph, it appears to be relating to 3.22 crores only.
I am grateful. This is what it seems to be.
Yes, that's right.
So this is the explanation of one of the figures at
That's
paragraph
right.
7.
So we are not concerned with that.
So now we are not concerned with
Okay.
that.
What about the next?
Then kindly see paragraph 9.
Yes.
In fact, permitted to be para 8 as well. Further, in case of 3 of 2015 para 8, PUSNF has passed order dated 12/11/2016 directing respondent to prepare fresh bill on the basis of reduced contract demand considering the date of approval for reduction of load as on 7/4/2011. That in the light of the order passed by so and so, KYS recasted from 14/2011 on the basis of reduced contract demand 2900 kVA instead of served bill of contract demand 5100 kVA and the difference of already served bill up to November 2016 and recasted bill of rupees. This is the second amendment. 2.58 crores was added in abeyance.
Yes.
So total kept in abeyance amount became rupees 5.79 crores in two parts so and so. And a request letter was written to law officer for filing of appeal against the order of PUSNF. At the time of online bill generation of SRIT, the amount was shown as rupees 4.56 crores. In SRIT bill, the amount of rupees 5.79 crores was shown only as one part and etc. My submission matters, I mean, I am not too clear what exactly they mean. But over the page, again, para 10 talks about the first amount. An appeal has been filed by ombudsman and a writ petition is pending consideration.
That's right.
But paragraph 12 is the second amount. It says, therefore, due to pendency of matter of KV at different level, amount was kept in abeyance. There is no justification about because the second matter, the second figure.
They have tried to mix up all the figures.
And admittedly, the second figure it was never challenged.
I just want to know from you, is there any common thread of dispute running amongst all the bills? Is there any common thread of dispute? Maybe in principle or in law, whether the KVA is to be charged in a particular manner. There could be different periods, the load is being reduced, but there could be a identical dispute running through the entire period. Is that so?
No, to my understanding, no. One of the figures which was already order was passed in my favor, that never came to be challenged by them ever. They also have noted that this amount is something we have only kept in abeyance for further instructions. There is nothing beyond with respect to the second figure. The first figure, yes, there is a common dispute which is run up to Supreme Court pending consideration. But more important, the arrears what they are trying to say, which is that is at paragraph number 14, if I may be permitted to show.
Yes.
That it is stated that letter number so and so dated 26th April 2023. This is the last provisional bill. Has been served to the petitioner, Messrs. KYS, along with the revised provisional final bill amounting to rupees 7.49 crores only, and rupees 2,500 as meter removal disconnection charges as per final reading, and Nigam's meter and materials removal report dated 27/2/2021. That on perusal of the revised provisional final bill, the balance calculation for reduction of bill amount has been given to arriving the total bill amounting to 7.49 crores. Now, this is exactly what your Lordship had wanted by the order of 13th October to give a detail of all these, which in this affidavit they did not provide at all. This led to your Lordship's order of 1st December 2023.
They have filed a response to your affidavit. I think some calculation, some chart I have seen somewhere.
Yes, I'm grateful. So thereafter, there was another one which was filed on 8th of January 2024.
Yes, I remember there is a chart given. (8th of January 24). They gave the disconnection notice, perhaps.
Disconnection notice was much earlier, Your Lordship. This is after Your Lordship's second order, then again a second, the supplementary affidavit was filed.
Yes,
this is of 8th of January 24.
8th of January 24. Yes.
May I invite Your Lordship's attention to paragraph 5.
Yes, paragraph 5. Yes, that's right.
That in this regard, may I permit to read it?
Yes.
That in this regard, it is stated and submitted that the electric line of consumer has been disconnected normally on 27/7/2021, which has been communicated by EEE MRT Jamshedpur by letter number 121 dated 28/7/21. Accordingly, the revised provisional final bill amounting to rupees 7.49 crores has been served with the petitioner, while letter number 1000 dated 26/4/22. The detail breakup of bill is as below. And then they provide these details. So kindly see the details. One is net assessment from August 2009 to July 21, including assessment of rupees 16.37 in July 2021. This is 2.21 crores. Current DPS 7.55 lakhs. Arrear energy charge 704 crores. Arrear dues 4.06 lakhs. DPS amount adjusted is reduced to 39.85 lakhs. And amount deleted on account of difference of contract demand is less 1.47 crores, and that's how they've come up with 7.49 crores.
This arrear energy charge 7.04 is relating to which period?
That exactly is my summation for Lordship's kind consideration. They have given a table, but there is no detailing at all. So even today, in my summation, they are as clueless as we were earlier. On 13th October, when your Lordship had wanted them to file all the previous bills in support of their affidavit. Even today, there is nothing on record to show what is the basis. So this entire detailing of 7.49 crores in my humble submission is of no consequence. So this is the third larger figure, of which this is the only detail which they have provided.
And what about serial number 6? They are adjusting your refund amount perhaps.
So no. So these are two independent 6 and 7 independent of the present refunds we are asking for.
Okay, this is independent of the present refund.
Independent of these two other.
How do they account for your refund claim with regard to other bills? Which you see, you have three components. One is pending before the Supreme Court, and two figures you are harping on refund, right?
Yes.
How do they account? Under which head do they account for the remaining figure?
Now, interestingly, serial number 6 is the same heading for which they allege is pending in Supreme Court. So they're actually giving me the benefit, half of benefit for that same amount. Kindly permit me to read. Amount deleted on account of difference of contract demand charge and actual KVA with DPS from August 2009 to April 2010.
So this benefit they are suo moto giving you.
Yes, suo moto for a certain period, they're admitting that I'm entitled to.
And what about serial number 1? This is pending where? Nowhere.
This is nowhere. Again, serial number 1, we are clueless, Your Lordship, in my humble submission as to what is the basis of all this net assessment. Because there is no document, no bills, nothing on record. Neither have we been supplied with anything. The same then connects with number 2, current DPS. And number 1 and 3 seems to be again kind of same overlapping arrears of energy charges. And then arrears
It
of
appears
ADDs.
that this record requires a lot of reconciliation of accounts of both the parties.
My submission is this. Your Lordship, kindly see Your Lordship's earlier order of 1st December. My Lord said specifically required them that to file an affidavit but give supporting documents. Now clearly twice chance has been given and they have nothing on record to show. And may I just also indicate another very striking point. May I invite Your Lordship's kind attention to my note at page number 3, paragraph 9.
Yes. Yes, please.
Page 3, paragraph 9. Further, the respondents have been demanding different dues under different bills which cannot be reconciled in any manner. Now, kindly see over the page the table which I have made on the basis of documents which is on
Your
record.
written submission which has been placed on record does not tally with whatever you are submitting.
I'm so sorry, Lordship. Maybe paragraph 9 might be the same.
Paragraph 9 is a longish paragraph. In terms of the impugned bill dated 26/4/2023, the second admitted amount is 2 crore 58 lakhs. This is para number 9.
My sincere apologies. May I invite Your Lordship's kind attention? There is a table.
That table is not there in your written submissions. Have you got that, Mr. Agarwal? Your table is not there in your submissions on behalf of the petitioner, filed on 1/2/2024.
There is a table at paragraph 9.
It's not there. Mr. Agarwal, just have a look at this. Either did you?
Manoj, I'll just indicate what the table has.
Even the written submissions that has been given to the other side also does not contain any such table.
Manoj, may I just indicate what the table has? It has a comparison of 4 documents on record. The first document, the electricity bill shows arrears of 7.82 crores.
I can't really appreciate your argument unless the table is there before me, and there is a complete lack of communication between you and your counsel here. And whatever has been filed does not tally with whatever you are saying. Yes, Mr. Agarwal? There is no table. Then the senior counsel is referring to the table. Where do I look for it?
The table not saying. The table may be.
No, it can't be like this, Mr. Agarwal. Mr. Agarwal, please, you see, there are huge figures involved here, over here. You are asking me to go into so much of accounting.
No, I'm not saying.
Then?
Provide with a table. We'll file the revised lot.
So you have wasted our time for half an hour.
That was my apologies for that, Manoj. I think there must be a. So may I just indicate why I was showing those 4 documents? It is a comparison of 4 documents on record.
I can't really appreciate your argument without
I understand.
whatever you are. There are so many figures, so many calculations involved. This is a case of 2008. Otherwise, we would have referred it to the forum for decision. We don't want to do that. When will your Advocate General be available? What is the date he has asked you?
Lordship.
Don't tell me any date. Please don't.
Lordship, any date by week.
No, any date means today. What do you mean any date?
Next week, ma'am, Lordship.
You be very, very sure about whatever date you are asking for. Because then I will not adjourn it.
It's the first week of March.
You choose your date.
On
Date is your choice, adjournment is my choice.
On 1st March,
All right. You file your fresh written submissions, there is a mismatch, but you do it by tomorrow or maybe by Monday.
It will be done.
And it will be better if you do it on affidavit. Right? And we want there are so much of voluminous records. You can give your convenience compilation such that the relevant documents is readily available with us for arguments, right?
I will do so. It should not be more than 20 pages. We'll do
Yes, convenience compilation is always better.
Lordship.
What's your full name? Mr. Devashish Bharuka, learned senior advocate, has joined online along with Mr. S.L. Agarwal, who is present in the court, and MS Ayushi.
Just Ayushi.
Give your name, please. There should not be any error in your name. Appearance detail. The hearing of the present cases have commenced. The learned counsel has referred to the written submissions filed, found on record. He submits that he would be filing a fresh written submissions as some more facts are required to be brought on record to the written submissions. Let the written submissions be filed on affidavit. The learned counsel, appearing on behalf of the respondents, has submitted that the matter has to be argued by learned Advocate General, and he submits that the learned Advocate General will be available on 1st of March to argue this matter. Let a convenience compilation be also filed by the petitioner. it will be open to the respondents also to file their written submissions based on the written submissions which is going to be filed by the petitioner. That would be good. Pose this case for further hearing on 1st of March to be taken as a first case. Let this matter be treated as final.
Really great.
Congratulations for your senior gown. We saw it in the live now.
Grateful, Lordship.
Actually, Lordship, we had got a ticket for yesterday evening. It was cancelled. Today morning, it was also cancelled. All the flights cancelled. Therefore, he could not make his appearance, and there was some gap.
There is no gap in online hearing. There is no gap at all.
हम लोग आप इसका गैप दोनों आदमी
Okay, before Lordship physically and assist this vote.
Okay.
all right.
Item 12.
You have understood?
Yes, sir.
Right? There are previous orders also. If you are not able to explain those figures, we will have no option but to quash the bills. And bills are running to 7 crores of rupees. So you should be very, very careful and file a response to the written submissions because they will be bringing all these errors of your affidavits on record even in the written submissions. Okay?
Item 12, WPC 2560/2021.
Who is for the petitioner?
Yes, Lordship, last occasion, argument already completed.
Argument completed? Who argued the matter last occasion?
We were required to furnish the written notes of arguments. That's here submitted also.
You forget it. You argue your matter. Arguments completed. Who said? You were there? Your name is Mr. Arvind Kumar?
No, my name is Nasim.
I must tell you that arguments were not commenced also. Just opening sentence was there that it is an admitted amount which is to be defined.
Yes, and Lordship order was the synosis and date
You
list.
forget it. You don't file it. We don't bother about it. You argue your case.
Already filed हो चुका है.
File हो चुका तो case बहस करें.
Yes. Last order may be seen, Lordship.
I've seen it.
Yes.
You argue your case.
Yes, my case is that tender is not completed. I already deposited 28 lakhs.
Argument can't commence in this manner. You just tell us what is the tender, what are the facts.
Yes, yes.
You have filed your written submissions?
Yes.
Where is that?
Dated 16th January 2024. Earlier was
Okay,
also.
fine.
Yes.
Okay.
The application was invited for the Bandobasti settlement of Sariyat Dak Bakta bus stand Lohardaga for the period of 12 months. That is the financial year 1st April 2020 to 31st March 2021.
That's right.
On dated 16th March 2020, petitioner participated in the auctions of Bandobasti Sariyat Dak Bakta bus stand Lohardaga and bid open in favor of the petitioner. As a higher Sariyat Dak Bakta on auctions amounting of rupees 38,15,000 for the financial year 2021, 20 to 31st March 2021. On 16th March 2020, but neither contract agreement has been executed nor work order has been issued before 31st May 2020. Therefore, no registrations of the contract in the office of the registrar on or before 31st May 2020. Petitioner has deposited a sum of rupees 24,80,008
Now you
rupees.
tell us one thing, right? Ultimately, you did not enter into agreement.
Lordship.
Ultimately, the agreement was not entered into.
As because no work
Whatever
order.
be the reason, but
Yes.
agreement was not entered.
Yes.
You commenced the collection of tax also.
No, never. I denied all the time.
But they have said that you commenced the collection of tax. They have said so.
They
in their
made an
affidavit.
inquiry. They made
They made inquiries.
Yes.
They say that you
Whatever-
commenced collection of tax.
Yes,
Now you tell us that how this kind of a dispute can be resolved in the writ application.
Yes, because earlier contractor was another And my
You see,
contract.
we cannot enter into this kind of dispute. You say that it's an admitted amount, it is not an admitted amount.
Yes.
Lordship, I'm relying upon two judgments of the Honorable Apex Court as well. This is my
This is not an admitted amount.
Yes, Lord, I have deposited. And
You have deposited is an admitted fact, but the amount that you are claiming cannot be refunded like this.
my amount has not been forfeited till date.
We will not enter into. You go and file a commercial suit.
My lord, simple case.
It's not
The contract has not been completed.
You have not entered into agreement in spite of there are so much of.
There is no agreement. So my amount has been lying
you
in
have
the.
collected tax also.
No,
As
never,
per-
never. This is not the case.
There are
This
two
is not the
inquiry
case.
reports
No,
on
no.
record, Your Lordship.
Wait a second, Mr. Arvind Kumar. When you say that this is not the case, you read the counter affidavit.
Yes. Yes.
And then you see, you cannot get away with that.
No.
This is not the case.
No.
This is their case. This is their case. That you collected the amount also.
My lord,
There are two inquiries also.
दूसरे जो कलेक्ट कर रहे थे ना वो दूसरे पर्सन थे आई वाज नॉट देयर
Very good.
मेरे नाम से कलेक्शन
They have said that they are your agents.
they said but they I am
So
saying
who will prove whether they are your agents or they are not your agents?
one thing lord
अभी I've heard you enough. WPC
उस
number
समय
2560 of 2021.
कोरोना पीरियड चल रहा था
हम समझ रहे हैं.
व्हीकल्स
आप
were
no-
not flying so there is no question that
No, we can't adjudicate such disputes. Show me that.
Yes, Your Lordship, I have given the written notes of punishment.
he stated
Two
in
judgments
that
have been annexed in that written notes itself, Your Lordship. But it's not paid.
68
This has not.
हाँ 68
State of Bihar and others versus Giant Plastic and Chemicals Limited is the first one.
लिखिए.
60
WPC number 2560 of 2021. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. On the last occasion when the case was taken up by this court, the counsel for the respondents had not appeared. However, some submission of the learned counsel for the petitioner has been recorded. The order dated 5/1/2024 is as under. The learned counsel for the respondents, while opposing the prayer of the petitioner, has submitted that the present writ petition that disputed questions of facts are involved in the present case which cannot be adjudicated under writ jurisdiction. He has also submitted that a detailed counter affidavit has been filed whereby the inquiry reports have been brought on record and the petitioner had also collected the amount for a substantial period involved in this case through himself or his authorized agent. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2002 bracket close 1 SCC 216 para number
6, Your Lordship.
para
3 and
6 and also judgment reported in bracket 2005 bracket close 12 SCC 725 para number
7.
para 7. In response, the learned counsel for the petitioner has submitted that there are no disputed questions of facts involved in the present case. He has also submitted that during the intervening period there was corona and
contract was not complete
and therefore the contract was not complete. He has submitted that the amount which was deposited by the petitioner against the tender is required to be refunded to the petitioner and therefore the present writ petition is maintainable and appropriate order should be passed in the present case. This is your submission. After hearing the learned counsel for the parties and considering the facts and circumstances of the present case, this court finds that it is the case of the petitioner that applications were invited for bandobasti settlement of Sariyar, Dag, Bakta, Bus Stand, Lohardaga for a period of 12 months from 1st April 2020 to 31st of March 2021, in which the petitioner had participated in the auction of Bandobasti of Sariyat, Dak Vakta. What is Dak Vakta?
डाक वक्त डाक बोलने वाला bidder, bidder.
Dak Vakta Bus Stand Lohardaga. And the bid was opened in favor of the petitioner for an amount, as the petitioner was the highest bidder, but neither the contract/agreement was executed nor the work order was issued before 31/5/2022. It is further the case of the petitioner that therefore there was no registration of contract in the office of the registrar on or before 31/5/2020. The petitioner had deposited a sum of rupees 24,80,008 as an advance to Nagar Parishad Lohardaga by receipt number 4017 dated 17/3/2020, and for an amount of rupees 23,04,008 and another amount of rupees 1,40,000 on 19/3/2020, total being 24,80,008. But the remaining amount was not paid as the contract was not executed. It has been asserted by the petitioner that the petitioner never started collection of taxes/chungi, etc. On the other hand, a counter affidavit has been filed in the present case wherein the deposit of the amount by the petitioner, though not in dispute. Deposit is not in dispute.
65% they had deposited.
Okay.
The rest 35% they had to deposit,
Okay.
they failed to do so.
65% of the amount was, is deposit of 65% of the amount has not been disputed.
Yes.
But for the remaining 35%, it has been stated that it was not deposited
It is in
as
the terms
per
of-
the as per the terms of the tender.
Yes.
It has also been stated in the counter affidavit that time was that the petitioner did not enter into agreement on account of non-cooperation on the part of
non-registration
the
of themselves.
on the part of the petitioner and on account of non-registration by them as per the terms of the tender itself. Yeah, it has also been brought on record through the counter affidavit that there has been inquiry reports against the petitioner/their authorized agent, which indicated that the taxes were collected by the petitioner
Petitioner or the representative.
or their authorized representative. After going through the records, this court is of the considered view that there are disputed questions of facts involved in the present case, which would further require interpretation of terms and conditions of the tender, and in view of the aforesaid judgments which has been cited by the learned counsel for the respondents, and this court is of the view that such disputed facts cannot be adjudicated under Article 226 of the Constitution of India, and therefore the present writ petition is hereby dismissed.
Liberty may be.
The liberty is reserved with the petitioner to pursue their remedy as may be available under law.
Lordship,
This order will, so far as observations made by this court in this order is concerned, the same will not prejudice either parties.
Lordship, only one thing, Lordship, may consider only my rejoined as para 68 and 67.
Please.
For admission, item 13, WPC 774 of 2016.
This is against the confiscation proceedings.
We have challenged the order at Annexure 12, page 68, asked by the revisional authority, remanding the matter back to the Deputy Commissioner. In this case, the allegation is that the Haiwa dumper of the petitioner was carrying 400 CFT of the stone boulder. That was finally intercepted. And the allegation is that it was quarried, this boulders was quarried in the mine, loaded in the truck, and it was being transported. This was the allegations. Now, after these allegations,
You are the owner of the truck?
yes, only after this allegation, the confiscation proceeding initiated before the DFO. DFO has taken into account the prosecution report, which I have enclosed. The prosecution report of the own department of the officers does not disclose that, rather they say that this stone was not quarried in the mine as alleged. My submission is only
was it found in your vehicle?
It was found in mine.
It was intercepted and found in your vehicle?
Yes, it was.
So what explanation do you have to that?
Because it was not mine, it was being transported by a valid challan. It was not mine anywhere in the forest. It cannot be a forest case. My only submission is this. Because the matter which was remanded back to the Deputy Commissioner has passed the order for release of the vehicle.
So when there is an order of remand, so why should we interfere?
Yes, the reason is why, we can see on what basis the remand has been made. That is important. Question is, that is, kindly come to page 69.
Page 69.
The last paragraph, A. The DC, you also forgot A. The DC in his order has stated that the inquiry report of the range forest officer Padma clearly mentions that no spot of illegal mining was found in Donai Khurd forest area. The report is further stated to mention that the stone boulders on the highway were not taken from any forest area. This aspect of inquiry report, a copy of which is not available in this court, is clearly in the contradictions of the following paragraphs mentioned in the order passed by the learned DFO.
See, there is nothing. They will examine everything once again. What's the big deal about it?
No, there is no. My submission is there is no stay also, but it's till date the deputy.
No, they will give them the date. When do you want to appear?
No, my submission is only this.
You see, against an order of demand, it is very difficult. You see, even if the authority has.
If Lordships will find that the last 10 years I have been only harassed for no Milord's fault.
We will ensure that there will be
Milord's,
no more harassment. When will you pass the order?
Your Lordship, maybe within 12 months.
Again revision. After Deputy Commissioner, again revision. Again I am coming to this court, again remand.
No, they will pass a speaking order.
Can you Lordship?
They will verify. We cannot verify.
Not question of verification. I have enclosed the report.
We will not. We will not
that
go into
report,
that.
they are accepting it.
No, whatever it is.
That report, they are accepting it. They are not disputing that report.
You might not be cooperating.
Where? I have not even received a notice from the Office of Deputy Commissioner.
You did not go. That there is an order of remand, you pass a fresh order. Is it not your duty? They will give you an invitation card.
Milords, invitation card cannot be given anywhere. Milords, the question is, Milords, my submissions will be recorded, Milords.
Not,
only
I
this.
will record it.
My submission is first, Milord, that the prosecution report, which is Annexure 4, which categorically says that, Milords, the mine was not quarried in the forest as the allegation which has been made, and the only ground for confiscation of this dumper. This is one. Milord, this was considered by the.
What were the documents supporting your stones in your dumper?
That was.
You must be having some challans, transport challan.
Challan have enclosed.
From where did you purchase it?
Which I have purchased from the person that was also enclosed. My submission is, that's what I say. My submission is everything was on the record, but what was taken into account is only the report of the prosecution. The prosecution report, they are taking it, they are just recording it otherwise, which is not in the prosecution. So my first submission is, the DFO, who is the authority, the confiscating authority at Annexure 7. Now he has taken into account the prosecution report at page 52 of my brief. Paragraph, this is page 52. Where it categorically says that in the meantime, I am reading the second paragraph. In the meantime, the Range Forest Office, Barhi, submitted the detailed prosecution report in the matter. Perusal of the prosecution report revealed that the beat officer Padma Beat had conducted a detailed inquiry in the matter. He verified the spot with the village map and found that the place of occurrence lies in 1781 of Danoi Khurd forest, which is a notified forest. No, this is not in the report. I have enclosed the report arrested for. My first submission is this.
The DFO, while passing the confiscation order,
No, they are interpreting it in another way. They say it was found to have been quarried, lots at a particular place.
so this was totally error of record.
Error of record. Then, lots, therefore, the appellate authority, lots annexed page 57, annexed read the deputy commissioner. Considering this, lots.
That's right. Okay. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the revisional authority by the impugned order dated 11/1/2016, though has remanded the matter before the deputy commissioner for passing fresh order after taking into consideration the materials, but all the relevant materials are placed on record before this court, and the petitioner has been unnecessarily harassed, although the prosecution report was in favor of the petitioner. The learned counsel has also submitted that the confiscation authority, while considering the prosecution report, had committed error of record, which led to passing of the order of confiscation, and ultimately the revisional authority, you filed revision? Ultimately the revisional authority had remanded the matter to the
Deputy Commissioner's appellate authority.
To the appellate authority for consideration. He has also submitted that after the order of remand passed on 11/1/2016, no notice of hearing has been fixed by the appellate authority.
Your Lordship should not say fixed. My submission
That's
was
it. Enough.
No, it has not. We have not received petitioner. Petitioner is here present. He has. I have asked him. He has not received any notice from the office of deputy commissioner.
Anyways, let's not write it. The learned counsel, appearing on behalf of the respondents while opposing the prayer, has submitted that this court may not enter into, may not set aside the order of remand, and it is for the authorities to take into consideration and examine the materials on record and then pass fresh order. She submits that the entire proceeding can be concluded within a period of 1 month if the petitioner cooperates with the proceedings, and any date of hearing be fixed by this court itself for the appearance of the petitioner. यहाँ record तो नहीं मंगाया गया ना?
नहीं record नहीं.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that an order of confiscation was passed against the petitioner, White order dated?
Order dated, Lordship, 8th July 2014.
No, 5/6/2013.
Yes.
White order dated 5/6/2013 in confiscation.
No, 16. Sorry, Lord. Page 668.
Page 49.
Page 68, Lord. The order passed by revision case number 28.
No, was passed by the confiscation authority in confiscation case number 73 of 2012.
That is not under challenge.
That is not the confiscation case. That was under challenge before the revisional and the appellate authority.
Yes.
You know, I'm just giving the background.
Okay.
On 5/6/2013, as contained in memo number 1889 dated 5/6/2013, against which the petitioner had filed appeal before the deputy commissioner, and the appeal was dismissed. However,
Page 57.
Dismissed by the order dated?
It was allowed, Lord.
It was allowed.
Yes, appeal was allowed.
Appeal was allowed by the order dated?
5/8/7/2014.
8
July.
7/2014. wherein following directions were issued. However, before the revisional authority order dated 11/1/2016 was passed and following findings were recorded, and the matter was and ultimately the matter was remanded back to the Deputy Commissioner for passing fresh order after hearing both the sides. This court finds that this court is not inclined to interfere with the order of remand. It is essentially for the authorities to examine the materials and pass fresh order. It is expected that the Deputy Commissioner will call for the records from the confiscating authority and examine the materials on record and pass fresh order in accordance with law. The petitioner to appear before the Deputy Commissioner कहाँ का? Hazaribagh on एक date दीजिए इनका appearance का बताइए कब appear होगा your counsel your parties here on 18th of March 23 at 11 a.m. and upon his appearance the parties be heard and appropriate order be passed by the Deputy Commissioner in accordance with law. The order to be passed be communicated to the petitioner through speed post. To the parties, आप भी तो appear होंगे Forest Department. The appropriate authority of the Forest Department shall also appear on the same date. Next.
Passover case item.
Other cases will also be called out. Please don't leave the court. After these, yes.
Yes, Mr. Sharma is online.
Yes. Where is the other side? They are not coming. They are not interested.
Mr. Sharma is joining from the other side.
Okay, he's from the other side. Yes, Mr. Sharma.
Leadership, I am for the response number 2, Lajpat Bhajanka, in item number 1 to 4. In 3 items, the 3 matters, we have already signed the joint compromise memo, but in 1 it could not be signed. Kindly adjourn the matter for 2 weeks. He will be available.
No, we have been adjourning the matter for quite some time. We have been adjourning the matters on number of dates.
No, Leadership, I am asking first time. Otherwise, I have never asked an adjournment in any case in which I have.
No, you are asking for the first time, but your clients have been asking for number of times. Your local counsel, Mr. Abhay Prakash, has made prayer for adjournment time and again, and on the last date he assured that he will not seek any further adjournment.
I assure him kindly pass over for 2 weeks. He will be present in the next week for the signing.
I wanted to vacate all the stay and dismiss all your compromise petitions. You can't have it like this, Mr. Sharma. The investigations are stayed. You see, there are serious allegations. Still, we were just thinking that there has been a compromise. It's okay. We will exercise powers under 482. But you have taken us for a ride.
No, Leadership, in 3 matters we have already signed a joint compromise.
You see, it cannot be partly done. Because there was a compromise in connection with all the matters.
A compromise in all the matters.
So it cannot be partly done. And you have got all your criminal cases have already been quashed by this court. So you are happy with that. When it comes to the petitioner, you are not cooperating.
Even Lajpat Bhajanka is available on the last month in this court. But because one of the petitioner was not present, it could not be signed.
You just tell us when will he come. You just tell us. You just give a date. When will he come? We'll ask the petitioner to be present.
Keep it on.
No, I will keep it on any date. But you just tell us that when is your party willing to come to Ranchi?
He will come on in the weeks starting from. give me only 1 minute. Starting from 12th. Kindly keep it on 16th. He will sign it on 13th or 14th. Any.
No, 14th is on holiday.
14th is a holiday. Your client is a local person?
No, he is also brother, but I shall call him. Any date
You just tell us. You just give a date. His client will also come.
He will come. He will come on 13th. He will reach.
13th.
Yes.
13th is a good day for both of you.
No problem.
Right.
13th is the date of the court or
No, 13th is the date which you propose that your client will come to Ranchi.
no, either 13th or 14th. Only
14 is
a
not
holiday, so
possible.
it's
14th
not
is a
for
holiday.
Okay, if it is holiday, he will come on 13th.
13th.
The learned counsel for the parties are present. Mr. S.K. Sharma has joined online on behalf of respondent, private respondent in CRMP number 694 of 2011.
Yes.
Right? The learned counsel.
All 4 cases.
Sorry?
In all 4 cases.
In all the 4 cases. Mr. S.K. Sharma has submitted that by way of last indulgence, the matter be adjourned, and in 3 cases, joint compromise petition has been filed, and in 1 case, it will be filed, and the matter be posted on 6th of March. On 6th of March.
Yes.
नहीं एक सेकंड
He shall reach
कब
by
13th को बोल रहे हैं ना वो आएंगे
he shall reach by 13th.
Okay, we can post it on 16th. Okay, on 16th of February. The learned counsel has submitted on instruction that his client will come to Ranchi for the required purpose on 13th of February 24. Right? Okay. Post this case on 16th of February 24. That's all?
Also case item 5, WPC 7479 of 2013.
देखिए किसी का ना
नहीं
किसी का
petitioners are made the shareholder.
Where is your written submission?
That we have 5 million with the supplementary affidavit. क्या तारीख को फाइल की?
It is not there. I have not come across a situation where written submissions are filed on affidavit.
Well, since the question of law were also to be enclosed.
So, question of law to be enclosed. These things, because there could be a mismatch in whatever you have stated and whatever is there in the written submission.
One important document was also required to be brought on the record.
You have not taken the leave of the court to do that. And you file it along with your written submission. I don't know, we have not come across such procedure, Mr. Singh. We have learned so much from you, but this procedure is never followed in the court. That in written submission, you will file a document which is not a part of the record.
I can.
Please show me please show me, throw some light on this kind of procedure. दिखाई जरा कहाँ है इनका written submission? We will not permit this.
Your Lordship, can we take the certain facts which I just want to speak?
No, I don't know. Okay, we'll discard your affidavit then. We'll reject your affidavit. You say that it will not be taken on record. We will remove it from the records.
Written arguments is there.
Written argument coupled with the document also.
One document will not.
How do we take it on record? Show us some procedure.
That document.
Show me some High Court rules, Mr. Singh. Please show us something. Let us also learn this procedure. And you don't object to this?
What we have got is a supplementary affidavit.
Supplement.
For me, it's a supplementary affidavit which has been served. I couldn't fathom that this is the written argument.
Yes,
And it ends with certain questions of law formulated. Where are the answers? Please have a look. Please have a look at the last effective paragraph.
Supplementary counter affidavit. Where is
Yes.
the supplementary affidavit?
Supplementary affidavit was filed on 24/1/2024.
And page 26 is containing the page 26 is containing few questions. So having received this affidavit, I shared it with my clients and for the RBI revision.
You have brought on record one handwritten document signed by people in the supplementary affidavit. And you say that this is a written submission.
Proceeding of the meeting has
What
been-
is the authenticity of this proceeding that you have not manufactured it now? What is the authenticity of this proceeding? And if this proceeding was relevant, why didn't you file it earlier?
For the time being, your lordship may kindly keep it aside.
Then I will record that you are not pressing this. You argue your case without the supplementary affidavit. We can't take it on record.
The supplementary affidavit, your lordship may know, but the argument attached therewith. I will be.
No, we will forget about this. You just argue your case in your own manner. I don't need a written submissions to decide a case. Do I? I can decide a case without a written submission also.
Well,
So we'll record that you don't want to press the supplementary affidavit. We will record that you will not press the supplementary affidavit.
well, yes, supplementary affidavit, your lordship may kindly say that I will not be taking help of the supplementary
Not
affidavit.
relying upon it. Will not form a part of the record. It will
but-
not form a part of the
Okay,
record.
No problem. But the argument there is, my lord, I should not be deprived from.
No. You see, arguments arising from the record, there is no problem about it.
Well,
You can always argue a case. There is no
Yes.
problem.
yes.
There is no
Yes.
problem about it.
Yes, yes.
When did you file it? बताइए जरा इनका supplementary affidavit file करना.
24 January.
24 से कहा.
24 January ना.
My.
देखिए, learned counsel for the parties are present. At the outset, the learned counsel for the petitioner has submitted that though a supplementary affidavit has been filed on 24/1/2024, but he will not place reliance on the same, and the same may not be taken on record. May not be treated as a part of the record.
Yes, exactly. This one. Minute.
Counsel for the respondents have no objection. Any objection, respondents?
No, not.
The learned counsel for the respondents have no objection to the submissions made. Accordingly, it is recorded that the supplementary affidavit said to have been filed on 24/1/2024 will not form a part of the record, and any document or material brought on record through the supplementary affidavit will not be taken into consideration. चलिए, अब बहस करें.
Lord, your lordship may kindly take few days. Lord, that appears from the petitioners. I challenge. They are the shareholder of the respondent bank. They
shareholders.
Shareholders. Lord, it is a bank. The respondent number 6. Respondent number 6 is the bank, Dhanbad Central Cooperative Bank.
सबका appearance kindly आप एक memo में डालिएगा, appearance memo में डालिएगा.
Respondent number 4, I'm sorry, not 6, respondent number 4.
Shareholders.
Yes, madam. They are the
Tundi
shareholders.
Primary Agriculture Credit Cooperative Society.
Ma'am.
You are the shareholder of the bank.
Yes, yes. Well, then before that, my Lord, your Lordship, kindly permit me to give certain introduction so far the provisions of the Act.
Yes.
So that it will be easy for us, my Lord, to explain the things. My Lord, there are, so far the cooperatives are concerned, there are 3-tier cooperative societies. Ground level cooperative society is called PACs and LAPs. That is ground level cooperative society in which an individual person, an individual citizen can become a member. Thereafter, there is a district level cooperative society. The district level cooperative society do not contains the membership of the individual, personal individual. In the district level, the primary sector, PACs and LAMPs can become the member of the district.
PACs is primary
primary agriculture cooperative society, and LAMPs who are large area. बताइए ना सर सरकार क्या LAMPs शॉर्ट में क्या वो LAMPs ये बेसिक हैं, ग्राउंड लेवल है.
LAMPs का फुल फॉर्म क्या है?
LAMPs का फुल फॉर्म क्या है? large area multi-purpose कुछ ऐसे ही है सर, exactly. Large area multi-purpose cooperative society.
Large area
multi-purpose cooperative
society.
Okay. All right.
ये ग्राउंड लेवल के हैं. उसके बाद नेक्स्ट लेवल है, दैट इज द डिस्ट्रिक्ट लेवल. द डिस्ट्रिक्ट लेवल इज कॉल्ड द डिस्ट्रिक्ट लेवल कोऑपरेटिव सोसाइटी और डिस्ट्रिक्ट कोऑपरेटिव सोसाइटी. मतलब दिस इज द सेकंड सेंट्रल कोऑपरेटिव सोसाइटी, दे आर आल्सो कॉल्ड. एंड द थर्ड इज द स्टेट लेवल कोऑपरेटिव. So these were the 3 systems of the cooperative society was existing in the whole Bihar. And then after bifurcation, it also continued in the state of Jharkhand. Then the state of Jharkhand decided to remove the middle level, the district level. Middle level means the state level and ground level to continue, but the middle level they wanted to remove. At that time, there were 8 middle level, district level cooperative societies were in the state of Jharkhand. One of the 7, your Lordship, kindly take my statement because that I am saying on the basis of the record which I had argued in other cases.
No. Things which are not born out of record, I will not consider.
There are 8 cooperative societies, and for the sake of information, I do not say only bank, X and Dunga, they were only in the profit and others were in loss. So what the state decided to merge all the district level cooperative society and to form them in the state level cooperative society. This decision somewhere taken by according to the statement by the cabinet on 8/10/2002. These are from the record.
Where is that decision?
Well, that is referred in Annex 3, which has been challenged in this case.
Where is that decision there? That decision must be on record.
Decision is not there, but this was referred in the Annex 3, which is impugned in this case. The Annex 3 is at page 31. This we have impugned.
The entire basis of the decision is not on record.
No, this is the estate. This is the estate's letter.
Where is the reference of this letter in this Annex 3?
My lord, the second paragraph. राज्य मंत्री परिषद की बैठक. We not got that. इसको एक बार प्लेस कर देते हैं. That will be more easy to understand the things. झारखंड राज्य मतलब आई एम प्लेसिंग लॉर्डशिप कैलिपर, झारखंड राज्य गठन के पश्चात शीर्ष सहकारी बैंक के रूप में राज्य में झारखंड राज्य सहकारी बैंक लिमिटेड का गठन करते हुए भारतीय रिजर्व बैंक नाबार्ड के आदेश एवं परामर्श पर बिहार राज्य सहकारी बैंक लिमिटेड पटना के झारखंड स्थित 5 शाखाओं का हस्तांतरण झारखंड राज्य सहकारी बैंक में किया जा चुका है एवं दिनांक 1/9/2012 से झारखंड राज्य सहकारी बैंक लिमिटेड कार्यशील है। साथ ही झारखंड राज्य सहकारी बैंक लिमिटेड को बैंकिंग व्यवसाय हेतु भारतीय रिजर्व बैंक के द्वारा बैंकिंग लाइसेंस भी प्राप्त हो गया। इस प्रकार झारखंड राज्य सहकारी बैंक लिमिटेड पूर्ण रूप से कार्यशील हो चुका है। राज्य मंत्री परिषद की बैठक दिनांक 8/10/2002 में लिए गए निर्णय के अनुसार राज्य में द्विस्तरीय प्रणाली सहकारी साख संरचना को लागू करने हेतु झारखंड राज्य सहकारी बैंक से सभी 8 जिला केंद्रीय सहकारी बैंकों का अवमेलन एमलगमेशन 8 बोल रहे थे हुजूर यहाँ पर आ गया करने के लिए झारखंड सहकारिता अधिनियम 1935 की धारा 44A के कैपिटल A कैपिटल के में A के प्रावधानों के आलोक में भारतीय रिजर्व बैंक के द्वारा भी सैद्धांतिक सहमति प्रदान कर दी गई है एवं इस क्रम में कार्यालय के पत्रांक 2746 दिनांक 21/10/13 के द्वारा राज्य अंतर्गत सभी जिला केंद्रीय सहकारी बैंकों को झारखंड राज्य सहकारी बैंकों में अमेलन अमलगमेशन के लिए बैंकों के बोर्ड प्रशासक एवं आम सभा से आमेलन की सहमति संबंधी प्रस्ताव पारित करने हेतु निर्देश दिया गया। मतलब दे वर डायरेक्टेड टू टेक ए रेजोल्यूशन फॉर देयर अमलगमेशन। उक्त के आलोक में धनबाद केंद्रीय सहकारी बैंक लिमिटेड को छोड़कर मतलब दिस इज द रेस्पोंडेंट नंबर 4 ऑफ व्हिच मतलब द पिटिशनर्स आर मेंबर्स। उक्त आलोक में धनबाद केंद्रीय सहकारी बैंक लिमिटेड को छोड़कर शेष 7 जिला केंद्रीय सहकारी बैंकों के द्वारा अमेलन पर सहमति व्यक्त करते हुए तक संबंधित प्रस्ताव पारित कर दिया गया है। ज्ञातव्य हो कि राज्य में द्विस्तरीय प्रणाली अपनाए जाने से बैंक समिति की वित्तीय स्थिति सुदृढ़ होगी एवं इससे बैंक के सदस्य समितियों के साथ ही कृषकों और ग्राहकों को बेहतर बैंकिंग सेवा भी उपलब्ध होगी। इसके अतिरिक्त सहकारिता प्रक्षेत्र के तहत कृषकों को कम ब्याज पर कृषि ऋण इत्यादि भी उपलब्ध हो सकेगी। उपरोक्त तथ्यों पर सम्यक विचारोपरांत यह स्पष्ट है कि धनबाद केंद्रीय सहकारी बैंक को झारखंड राज्य सहकारी बैंक में अमेलित किया जाना दोनों बैंक समितियों के वित्तीय सुदृढ़ीकरण हेतु आवश्यक है एवं यह दोनों बैंकों एवं किसानों मजदूरों एवं ग्राम हस्तकारों के लिए हितकर है। ऐसी स्थिति में झारखंड सहकारिता नियमावली 1949 के नियम 39 के तहत धनबाद केंद्रीय सहकारी बैंक को झारखंड राज्य सहकारी बैंक में अनिवार्य अमेलन किया जाना आवश्यक है। अतएव उपयुक्त तथ्यों से संतुष्ट होकर बैंकों समितियों के वित्तीय हितों को दृष्टिगत करते हुए
Yes, what is the ground for it?
pardon.
Yes, what is your ground for
My
it?
letter let me complete.
I've read it. आपको लगा?
उसने कहा है इन्होंने कहा कि रेजोल्यूशन लेगा कमिटी will be taking the resolution. Committee has declined to formal. And this was the document which we have said, that's इसमें नेक्स्ट पेज में हमको थोड़ा सा रह गया कंप्लीट करते। नियम के तहत धनबाद केंद्रीय सहकारी बैंकों के बैंक प्रबंधन के आदेश दिया जाता है कि धनबाद केंद्रीय सहकारी बैंक को झारखंड राज्य सहकारी बैंक में अनिवार्य अमेलन संबंधी प्रस्ताव पर विचार उपरांत निर्णय के प्रयोजन से बैंक के शेयर धारकों एवं लेनदारों की आम सभा अधिकतम 6 सप्ताह के अंदर आयोजित कर लिया जाए, लिए गए प्रस्ताव से अधोहस्ताक्षरी को अवगत कराना सुनिश्चित करें. So this was the fact. Then the decision of refusal has been enclosed. And this decision of refusal has been enclosed as Annexure F, Annexure E to the counter affidavit filed on behalf of the bank.
ये आप अपना केस बताइए ना, काउंटर से केस मत बनाइए.
नहीं,
आप अपना
counter
रिट पिटीशन में आप
ये.
Let us see what was your case in the writ petition. No, don't try to make out a case from the counter affidavit. Let us see what is your case in the writ petition.
So that the fact be
No,
complete.
it will be complete. You see, para 2, para 3 is the question that you have framed, right? And then para 7. Yes, what was your case in the writ petition?
The rule 39 is not applicable so far the cooperative banks are concerned. This is the shortest argument, and the Reserve Bank has not granted permission for amalgamation so far the Jharkhand Agricultural Dhanbad Central Cooperative Bank is concerned. Well, this is the shortest argument which I am saying. I will be making the argument in detail. For that, my lord, your lordship may kindly come to see.
Now let us see. The first issue is this concurrence from RBI, right?
Pardon?
Concurrence from RBI is the first issue?
Yes. Consent of the RBI is the first issue. Your lordship may kindly look to the order passed by this court.
Now, under which provision this consent is required? Under which provision this consent is required?
Yes, the banking, since the banking law...
Tell us which provision.
Annexure 1 law. Annexure 1 to the...
Annexure 1 is... No, Annexure 1 is under which provision of law this concurrence is required. Under which provision of law? कोई act होगा, कोई guideline होगा, कोई rule होगा.
The 44 AK of the Cooperative Society
44 AK of the Cooperative Societies Act.
Chapter 6.
Only 44 K.
AK.
AK. पढ़िए.
Division, amalgamation, compromise. No order sanctioning a scheme of compromise or arrangement or amalgamation or reconstruction or of division or transfer of assets and liability of any cooperative bank. Well, it is not the cooperative society. That the distinction is here. Cooperative bank shall be made without the previous sanction in writing of the Reserve Bank. This is the requirement.
So this
And
was the
Reserve-
requirement.
Huh.
So it was the cooperative bank.
Yes, it is the cooperative bank. Respondent number 4 is the cooperative bank. It is governed under the banking regulation also.
Cooperative bank. So RBI's concurrence was required.
Yes.
According to you, there is no concurrence of RBI,
Yes.
or RBI
The
has.
counter, shortest point I have said.
Yes.
My lord, your
We
lordship
will
may-
deal it point wise. According to you,
Yes.
RBI has given concurrence or not given?
No, RBI had initially accepted the proposal. The word is accepted the proposal in relation to all 8 banking companies district level. Subsequently, the bank RBI has given a letter excluding the Dhanbad bank. That is the counter affidavit of the bank. And that
Who is appearing for RBI? Are you appearing? What is your stand? RBI has given the concurrence or sanction in terms of section 44 AK, or RBI has not
So
given?
so far this
इन्हीं से पूछते नहीं. He is the best person to say. Yes, what is your stand on this?
Just one.
इनका काउंटर का पैराग्राफ 16 देख लिया.
उनका काउंटर उनको प्लेस करने दीजिए. हाँ बताइए.
The initial document was 11 October 2013.
First, you tell us what is your stand. You are supporting him on this point, or you are opposing him on this point?
No, we have not opposed. We have just brought the facts on record.
Okay. What is the fact?
The approval was given but they must have to make some submission with regard to that. Annexure A, page 24
Of
is
the
that document
affidavit dated?
of the affidavit which had been filed.
Annexure A.
Affidavit dated 4/3/2023.
4/8/23. 4/8/23 का तो कोई affidavit नहीं.
This is how it has been stated in my. It's counter affidavit of respondent number 5.
Respond number 5. There is no such affidavit. ऐसा कोई affidavit नहीं पाई.
आरबीआई का काउंटर,
हाँ आरबीआई का
काउंटर है, उसका एनेक्शन बी देख लिया जाए.
एनेक्शन नहीं, स्टेटमेंट देखेंगे. स्टेटमेंट बताइए क्या है?
एनेक्शन बी डॉक्यूमेंट है.
डॉक्यूमेंट बाद में देखेंगे, स्टेटमेंट पहले देखेंगे. आप बताइए आपका क्या स्टैंड है? Show it from the paragraph
16.
Paragraph 16. Yes. Kindly read it.
And
Para 15 भी पढ़िए.
It may be read with para 15.
Yes. Read it.
Under section 44A(k) of the Jharkhand Cooperative Societies Act 1935, no order sanctioning a scheme of compromise or arrangement or of amalgamation or reconstruction or of division or transfer of assets and liabilities of a cooperative bank can be made without the previous sanction in writing of the RBI. It is submitted on the basis of the recommendations received from NABARD. RBI by its letter dated 11 October 2013 accorded in principle approval to the proposal of the government of Jharkhand for amalgamation of 8 district central cooperative banks with Jharkhand State Cooperative Bank. However, a revised letter was received in RBI from NABARD containing a revised proposal of amalgamation. And thereafter, the Reserve Bank of India, by its letter dated 18 November 2014, conveyed in principle approval to the revised proposal of the government of Jharkhand for amalgamation of 7 in Jharkhand other than Dhanbad DCC with
That's
Jharkhand
clean
State
check the issue.
granted final approval to the proposal of government of Jharkhand for the amalgamation of 7 with so and so subject to fulfillment of certain conditions.
Okay, so basically, so far as Dhanbad Central Cooperative Bank is
Yes,
concerned,
we have
even
been-
as per the affidavit of RBI, they have given only to 7, and
Yes.
Dhanbad Central Cooperative Bank has been left out. So their specific case that the required sanction is not there clinches the issue.
That has to be answered by state.
Yes, yes. What is your stand state? बताइए. आपके पास sanction आया है? कहाँ है sanction?
समरी हमारा एक
समरी नहीं बताइए, सैंक्शन दिखाइए आप हम. सैंक्शन आप हमारा 2 सवाल का जवाब दीजिए. अभी यस बोल दिए, सवाल नहीं पूछे अभी. पहला सवाल 44K का सैंक्शन का जरूरत था कि नहीं था, और अगर जरूरत था तो आपके पास सैंक्शन है क्या, और अगर जरूरत नहीं था तो भेजे क्यों? भेजे थे ना?
भेजे थे.
हाँ, तो इसका मतलब सैंक्शन का रिक्वायरमेंट था एज पर योर अंडरस्टैंडिंग.
हाँ, ये था.
वेयर इज द सैंक्शन?
आया है.
वेयर इज द सैंक्शन?
Kindly see the supplementary affidavit note filed on 13/3/2020.
13/3/20
Yes.
सप्लीमेंट्री दिखाइए. सैंक्शन आरबीआई का डॉक्यूमेंट दिखाइए.
ये डॉक्यूमेंट्स है एनेक्सर सी, तो नाबार्ड का डॉक्यूमेंट्स है.
नाबार्ड का नहीं, हमको आरबीआई का डॉक्यूमेंट चाहिए.
एनेक्सर सी एट पेज 26. उसमें स्टेटमेंट है. उसमें
हमको डॉक्यूमेंट चाहिए आरबीआई का. स्टेटमेंट से कैसे चलेगा? Which is a document of RBI.
NABARD has given that very document. झारखंड के 8 जिला केंद्रीय सहकारी बैंकों के झारखंड राज्य
जब आरबीआई बोल रहे हैं
Yes.
कि उन्होंने दिया ही नहीं सैंक्शन, तो नाबार्ड के बोलने से कैसे? Who is for नाबार्ड?
NABARD, nobody seems to be appearing. That's
Very
point number 6.
Then Lord NDC, other affidavit was also there.
Annexure K देखिए, पेज 38. पेज नंबर 38. पढ़िए इसको.
Okay. Amalgamation of 7 central cooperative banks with Jharkhand State Cooperative Bank. please refer to your letter dated March 17, 2017 on the caption subject. In this connection, we give our final approval to the proposal of the government of Jharkhand for the
ये
amalgamation
तो
of
7 वाला है.
seven district. ये 7 वाला है.
हाँ, 8वां किधर?
एक अलग एफिडेविट है 18/8/2021 का 18/8/2020. Annexure
बताइए.
Annexure F at page 29.
ठीक है.
29. भारतीय रिजर्व बैंक.
पेज 29.
Yes.
और कहाँ है इसमें सैंक्शन? 11 अक्टूबर 2003. बताइए, पढ़िए इसको, सैंक्शन पढ़िए.
Amalgamation of 8 CCB in Jharkhand with Jharkhand State Cooperative Bank. Please refer to your letter number such and such. We advise that we are pleased to record in principal approval to the proposed of the government of Jharkhand to the amalgamation of 8 district central cooperative bank in Jharkhand with the Jharkhand State Cooperative Bank as per recommendation inter area received from the NABARD. This approval may be
Yes, Mr.
conveyed to the
Neeraj,
government.
what is your
of
response
Jharkhand,
to
subject the
11th October 2013 letter which has been annexed with their counterpart?
फिर अगर देखा जाए paragraph 16 that has been second, he is talking about the first letter.
That's my annexure A.
This is
That's
your annexure A.
This is what I have commented upon in paragraph 16.
एक second.
This was the initial approval to all 8.
एक second.
Yes, Your Lordship. May I have a look at annexure A, page 24?
हाँ, yes. How do you explain this?
No, this has been revised. That's
This
what-
has been revised.
Yes.
sir.
Annexure B.
सर प्लीज आप ही के पक्ष में बोलते हैं, फिर भी आप बीच में इंटरप्ट करते हैं.
I'm sorry.
आपके अगेंस्ट में बोल रहे हैं, एक भी शब्द नहीं बोल रहे हैं ना. तो बैठिए, जो
In
छोटा
fact-
इशू में डिसाइड हो सकता है उसके लिए इतना क्या
In
सोचना?
fact, Your Ladyship, when we were called upon to give our notes and all, I find that it won't be possible to give a cumulative thing. So I prepared a small 3
No, no,
pages
you
list of
you
dates.
just explain
No,
this.
I'm just.
अभी खत्म हो
It is
जाएगा,
that
कुछ
only.
नहीं है इसमें.
It is not to favor or oppose any party. It is just
You
from
are
the
bound to
records.
be a neutral party.
Yes, it is just from the records. Court master साहब इसको खाली
ये बताइए, लेटर के बाद क्या हुआ? Annexure A के बाद?
annexure A के बाद B,
And what is your statement with regard to annexure A?
paragraph 16 itself.
Paragraph.
May I just read it again?
Yes, please.
Yes. On the basis of I'll skip the unnecessary.
Yes, yes, please.
On the basis of the recommendations received from NABARD, RBI by its letter dated 11 October 2013 accorded in principle approval to the proposal of Government of Jharkhand for amalgamation of 8 district central cooperative banks with Jharkhand State Cooperative Bank. However, a revised letter was received in RBI from NABARD containing the revised proposal of amalgamation, and thereafter RBI by its letter dated 18 November 2014. So this is our second step. Conveyed in principle approval to the revised proposal.
That's
of
right.
Government
So,
of Jharkhand.
so this.
Now it is for them to argue whether 8 or 7.
No, no, it can't
We
be
have-
like this, no. When there is a revision, the earlier letter will not survive under any
And then we have said,
circumstances.
please see, that we have enclosed 3 letters only. So let me just narrate what we have said about the third one. Bottom page 12. Thereafter, last 4 lines. RBI by its letter dated 30 March 2017 granted final approval to the proposal of Government of Jharkhand for the amalgamation of 7.
That's right.
So these 3 clinching documents we have enclosed.
That's
If anything else is to
Yes,
be said,
state. Now you explain.
Look, the
First, I will record your submission. Be very, very clear on this. Required sanction of RBI is required or not required?
Required.
Now, in view of the communications received from RBI, right?
Yes.
The earlier letter of 2013 stands superseded by subsequent letters.
Well, due to this read petition, there was the stay granted by this honorable
What
court.
stay?
That's why, my lord, they have again, my lord, they have made only 7 cooperative society. My lord. Kindly see, my lord, para 9.
When was
of
the stay
form.
order passed? When was the stay order passed? 2012-2013.
Yes.
But the decision which is impugned is at Annexure 3, page number 31. Right? This is dated 2/12/2013. Right?
Yes.
Okay. In this particular letter, is it mentioned that the RBI has given the sanction?
Annexure 3 of read, my lord.
Annexure 3 of the writ petition.
Second paragraph. Annexure 3 of the page 31. Read petition. In principle, that has been given.
एक सेकेंड, हमको 2-3 डेट नोट करने दीजिए. इम्प्यूग्न ऑर्डर का डेट बताइए तो. 2/12/2013. स्टे ऑर्डर का डेट है 20/12/2013. RBI का जो 3 लेटर्स हैं,
October 13.
ये 11/10/2013 RBI. इसके बाद नेक्स्ट लेटर कब का है इनका?
October 2013 RBI का.
हाँ, उसके बाद नेक्स्ट पेज है 18/11/2014. You see, there was a sanction by RBI on 11/10/2013, pursuant to which the decision was taken, which is impugned in the writ petition. Thereafter, on 20/12/2013, there was a stay order passed by this court, and in the RBI document, which is dated 18th of November 2014, it mentions that Government of Jharkhand should verify whether there are any orders of court in regard to one above before proceeding with the case. So, in the meantime, there were certain interim orders, and maybe the RBI thought or NABARD thought or the state thought कि जितना का हो जाता है उतना कर देते हैं, बाकी इसका बाद में.
इसके लिए इनका काउंटर कनेक्शन भी देखा जाए. स्टेट के काउंटर कनेक्शन, पहले फर्स्ट काउंटर कनेक्शन that is the letter of NABARD, dated 17/10/2013. Internal page 22. I will also got that.
Yes, I got that.
झारखंड के 8 जिला केंद्रीय सहकारी बैंकों का झारखंड राज्य सहकारी बैंक लिमिटेड के साथ सम्मेलन। कृपया उक्त विषय पर दिनांक 5/9/2013 के अपने विभाग के पत्रांक 700 रांची के संदर्भ में ग्रहण करें। इस संदर्भ में हम सहर्ष सूचित करते हैं कि आरबीआई ने आपके शीर्षांकित प्रस्ताव को इन प्रिंसिपल अप्रूवल प्रदान की है, जो निम्नलिखित शर्तों के अधीन है। Board and general body resolution to be passed by all 8 CCBS and JST CBA indicating their willingness for merger. Willingness for merger.
Okay.
And amalgamation.
So your case is that there was no willingness.
No willingness. That's why we came up before this court.
And you are still not willing to.
No, not really. Well, one provision of law to lordship can be put.
ठीक है।
एक और प्रोविजन है, बैंकिंग रेगुलेशन एक्ट का सेक्शन 44A है, वो इसमें रेलिवेंट। बैंकिंग रेगुलेशन एक्ट सेक्शन 44A, प्रोसीजर फॉर अमलगमेशन ऑफ बैंकिंग कंपनीज, वो इसमें रेलिवेंट होगा।
वो लगता है कंपनी से लगेगा।
कोऑपरेटिव ही से रिलेटेड है,
सेक्शन 56।
नहीं, इसमें तो कोई डिस्प्यूट ही नहीं है, sanction is required. When there is no dispute that the sanction is required, then under such circumstances, as long as the NABARD itself is issuing a letter of your concurrence.
Yes.
उसके बाद कॉन्फ्रेंस नहीं हो पाया, उसके बाद
नहीं, हम क्या इंडिकेट करने जा रहे थे,
इसीलिए उन्होंने चिट्ठी भी लिखी थी कॉन्फ्रेंस के लिए।
हाँ, इसीलिए।
नहीं तो क्यों लिखते?
हाँ जी, and that was the reason.
That was the reason. That is why they wrote it, and you don't agree to that.
एक बैकग्राउंड और बताना चाह रहे हूँ। जो 2002 में जो स्टेट गवर्नमेंट का रेजोल्यूशन हुआ, उस समय they have forcefully।
देखिए ऐसा है सर, I will hear you. 5:45 already बज चुके हैं। We'll continue hearing on the next day. You also, both of you, think over it. ठीक है? If this particular order, जो आपका, इनका तो सिर्फ इतना ही ऑर्डर है, इन्होंने इसको नहीं चैलेंज किया है कि उसके बाद क्या हुआ। इनको सिर्फ इतना ही था कि वो प्लेस करेंगे अपने वहाँ पर जो भी रिजोल्यूशन होना था। ठीक है? Now the point is, by pursuing to this letter, if the matter is placed before the board, then whatever decision they take, parties will act as per law. If there is any such provision that you can forcefully take them, then the state will have to take a decision to that effect. ऐसे तो नहीं हो सकता ना?
Yes, Lord, उसमें on that very point, Bihar Cooperative Societies Rules 1959, Section 39, Rule 39, compulsory amalgamation of society. That is there.
लेकिन आपने अभी compulsory amalgamation का power exercise कहाँ किया है? Because of the reason, as per the impugned order, you have just asked him to convene a meeting. You have asked him to convene a meeting. अनिवार्य। आम सभा करना था 6 हफ्ता में, आपको तो कन्वीन करना था मीटिंग, आप रिजेक्ट कर दीजिए प्रपोजल। फिर आपको मन करे तो अपना जो पावर हो एक्सरसाइज करिए।
In the counter affidavit, they have been closed that it has been refused by the court.
That is not under challenge.
They have no, but that is in our favor.
Maybe it is in your favor. We do not know. जब already refuse हो चुका है, इनको अपना जो मन हो अपना पावर एक्सरसाइज करे। पावर होगा तो करेंगे, नहीं होगा तो नहीं करेंगे। इतना ही तो है। If it has already been refused by the committee, then still they can exercise if they have any such power under that.
एक चीज केवल हम लोग
इसके beyond तो कुछ नहीं।
According to us, the rule 39 is not
वो
applicable.
देखिए उन्होंने अभी वो पावर ही एक्सरसाइज नहीं किया है, तो रूल 39 एप्लीकेबल है कि नहीं है, दैट इज द प्री मेच्योर क्वेश्चन. वी डोंट नीड टू एंटर इनटू दैट क्वेश्चन, isn't it? Done?
Beg your pardon. Annexure 3 talks of Rule 39. Annexure 3 of the writ petition talks of Rule 39.
They have not yet exercised the power under Rule 39. They have asked you to convene a meeting. Then that is all. We don't know. आप अपना मीटिंग करिए, उसके बाद आप रिजेक्ट कर दीजिए, फिर इनको जो मर्जी करेंगे. स्टेट से कैसे चलते रहे? रिजेक्ट कर दिए, बड़ी खुशी की बात है. अब स्टे तो नहीं चलेगा ना. रिजेक्ट कर दिए, एक सेकंड मिस्टर मुरारी, रिजेक्ट कर दिए, दे विल प्रोसीड इन अकॉर्डेंस विथ लॉ. इसमें क्या है? उनको जो उनको पावर है वही ना एक्सरसाइज करेंगे. 1 मिनट में
नेक्स्ट इस आदेश के आधार पर तो रिजेक्ट हो गया. अब रूल 39 क्या है?
देखिए ऐसा है, इनके इस आधार के रिजेक्ट हो गया तो टेक्निकली केस इनफ्रक्चुअस हो गया. Isn't it? Isn't it? Because the impugned order has taken its effect, they have rejected it.
What we beg to submit, Lordship, 41 AK frustrated RBI did not grant.
वो नहीं, देखिए ऐसा है, अभी स्टेट ने रूल 39 का पावर एक्सरसाइज नहीं किया है. So we are not going to decide whether and if they have exercised such power, that is not under challenge in this written.
This submission is for us kindly, that according to us, so far the banking cooperative societies are concerned, the Rule 39 is not applicable.
We will not anticipate anything. We don't need to say anything because this court, this record does not require any pronouncement on exercise of power under Rule 39.
ये हम रिक्वेस्ट कर रहे हैं.
नहीं, ये तो cause of action ही नहीं है आपका. Rule 39 का power exercise कहाँ किया है? It is not there in the writ petition at all. जो चीज writ petition में नहीं है, वो इशू को हम डिसाइड नहीं करेंगे.
39 के बेसिस पर ही they have directed to hold the meeting, that is annexure 4.
नहीं, that is not a that 39 के डायरेक्शन में फिर मीटिंग क्या होगा? वो सीधे टेक ओवर हो जाएगा. 39 के रूल में मीटिंग क्या चीज के लिए होगा? नो मीटिंग इज रिक्वायर्ड. क्योंकि उन्होंने जो चिट्ठी लिखी है दैट इज टू सीक योर कंसेंट, राइट? तो 39 में कंसेंट की क्या बात है? But to seek your consent, you have refused your consent.
Probably your lordship will be taking on the next day.
नेक्स्ट फ्राइडे को हम लोग नेक्स्ट फ्राइडे को तो और कोई मैटर नहीं रखे हैं ना ऐसा. एकदम पहला केस सर 2:15 बजे आ जाएगा, हम 2:15 बजे बैठ जाते हैं और पास ओवर हम नहीं करेंगे. अगर आप लोग नहीं आइएगा तो हम ऑर्डर डिक्टेट करना शुरू कर देंगे. नहीं, देखिए अगर ये आता शुरू में तो इतना दिन से चल रहा है, बताइए इसमें कुछ है? कुछ नहीं है इसमें, टूट मूट का उलझाया हुआ.
39 में तो एमलगमेंट करने के लिए कन्वीन करने के मेडिकल डायरेक्शन देना है. यही ले दिए थे कि आप
39 में
भी यही पावर है रजिस्ट्रार को before compulsory amalgamation exercise direct for convening the meeting and taking the concurrence. That is what the provision rule 39.
अच्छा ठीक है, देख.
This is what I'm listening.
We'll see that.
Lordship, 39 we will place. Get from